One. Here, earlier in 2025, two instructions were produced before this honorable court. In fact, for construction of the road, there were four tenders. Then subsequently, those tenders it was not being concluded, and it was and a decision was taken not to proceed with those tenders and to go for fresh tenders.
Yes.
Then subsequently, instructions produced before this honorable court. Some private lands are standing over that property, and
You have demarcated. We have demarcated.
demarcation report is also produced before this honorable court,
Trace map was produced.
and that also requires acquisition. Because today morning I discussed with the chief engineer, Roads One, what they have said that there is a further budget allocation for this particular project. They are going for further budget and provided it has to be approved by the competent authorities, and then the lands are to be acquired from the private parties, and thereafter the construction will go. So this will take some time. So that instruction they give writing. That is what.
Why don't you put it on affidavits?
But that is what I am saying, Manoj.
But only the entire I think the bottom line of the entire thing is that you can't show complacency in construction of a road because it is a very important means of a communications. So somebody has to commute from remote places. So how can you remain so stubborn in not doing it?
But in fact, tenders were there, but due to some local.
What is the local dispute? I do not know.
Could not be.
Then why the government is given a power of eminent domain? For what?
No, that was in 2024. So the instructions were produced in 2025. So today morning I have let them.
This one is the instruction that we have demarcated.
With the council. That land which they require for acquisition, that is no more required.
Are you an expert? Are you an expert?
I am single.
I'm asking you, sir. Are you a structural engineer? Are you an architecture? Are you some kind of a civil engineer that you know how to divert it, how the road should take a curve, how much curve is required? Everything. Do you have an expertise on that?
Norms are prescribed by Indian Road Congress. Norms are prescribed by Indian Road Congress.
Everything they can't go beyond it. Now they are the best. They are the experts. They know because if they want to, if some kind of a diversion is to be made, then in that event they are the best person to find out that what should be the width of the road diversion, how it is to be done. Everything they have to.
We have already delivered a judgment in Bhubaneswar, the Info City Road. There we have discussed the entire thing, how experts require deviation of road while constructing it.
The technical experts, technical people, we are not.
That is what I'm saying. So they are the best person to decide. If they say diversion will not be a viable solution, they have to go or make a road straight. If some private lands are to be subsumed into that particular road, for that they have to take steps for acquisition thereof, and which they are saying that we are going to initiate a proceeding for acquisition. So they will acquire that land and then they will go and construct. Let them file an affidavit disclosing also those facts. So later on they cannot digress therefrom. They can't digress therefrom. They have to stand. The learned additional Oh.
Again,
This is. Is
a substitute.
specs malfunction. Don't worry.
Item number 2.
After the query was settled in favor of the petitioner matters, when it was found that the itself is jungle matter. So they cancelled my with Tahsildar.
So you wanted a refund.
Refund of my amount.
What are you doing?
As per my instruction, already the proposal is under process.
That I have seen that you have said that the proposal for refund is already. Then how long will you continue to hold the money of the another person?
That will grant us 2 weeks time.
What 2 weeks time? Then we will grant them an interest to be paid. You are unreasonably withholding the money belonging to other. What is this? If you have decided not to continue with this, and then you have also decided to refund it, why you will not refund it? You will sit. You will just over the money belonging to other. They could have utilized this money for any other purpose. Why you are depriving them?
They have started the process in 2023. I will say.
23, we are in 26 now. Do you realize that you are withholding more than 3 years? When you have decided to refund it, no refund.
That will be column refunded next week.
What next week? This is something which is acceptable. You have to be very reasonable.
Yes.
They are not at fault. You can't blame them that they have committed any default. Then why? We are directing the refund of the amount immediately within 15 days with interest of 6%. No, you pay interest.
We
You have invested that amount in any fixed deposits or a bank. You would have earned the interest therefrom. 3 years you have deprived him of that particular money. He can't utilize the usufruct from there.
that's true.
What is this?
That's true.
Then
That's in here.
there's no justification that you can withhold the money.
From the date of deposit till its actual,
You pay 6% interest.
because of your delay in process. Date of deposit
That's the direct.
till actual payment.
Next week, you got the. Because for
It is submitted by the learned additional government. Fixed. There is a small part. Just one.
That an amendment was brought about the MMDR Act in 2021. Have flagged the amendment and the pink flag. Not to kindly take
What section?
Well, this section 8(4). Why it's section 8(4), but I will place that section. Reads that notwithstanding anything contained in this section, in case of government companies or corporations, the period of mining lease, including the existing mining lease, shall be such as will be.
Which one? Which one is the item?
Item 3.
Brother, should be. Release.
Should be placed before any other.
Item 4.
This is one. We are not inclined to take up. That is going to be released for us from this way.
On account of the Indian demand, the opportunity were not issued anything. Fortunately, my lords, and what had happened was that revisional authority was not taking up the matters and we are not able to press for interim orders. But in between the filing date and today, two of the matters have been taken up and interim orders have been passed. In view of this, the first two matters,
What is first time?
the revisional authority. In view of this, the first two matters may be disposed of.
First two matters means.
294 and 295.
I'm just passing the orders.
So the third matter remain. So
Third matter
we are reverting the matter to the regional authority to take
In
up
fact-
on a particular day.
My lords.
So that. Yes,
My lords.
that is what is it. Give it. Basically, the final relief has been granted.
My lords, because the state was said that.
No, that is a final relief.
No, the final relief will be the second and third of the relief.
Not the issue of the MDCC. What for? That's a final relief.
My lords, this is a corporate.
Your grievance is the issue of the MDCC.
Yeah, my lords.
So what, you have got the actually final relief?
In the
Yes.
first two matters.
All the key matters were listed. Yes.
Item number 5.
This deed was executed. The door of the.
There is not anything order. There is already, we have taken the decision in one of the bank.
No extensions are there given.
No, Rule 64, you have to take care of. Because they were prevented by an order of the entity. There was no fault which can be attributed to them. Where is that order? Kanti or Prashantu? This is the entity. Yes, go through it. See, director consider it. Take this. She has that copy. Yes. He has considered all the judgments. In the event, what we have said, that in the event they extend the period, they can. If they choose not to extend, then refund all the payment which you have made with interest. Yes.
Item number 6.
Good, you are defining the mining plan,
No,
making an access. Yesterday, we have already delivered the judgment.
Item 4.
The mining plan is sacrosanct. If there is any deviation or anything which offends the mining plan, you can't do it.
No, there's no.
There is an allegation of excess black stone to have been extracted
I'll take that.
beyond the mining.
Application may not be when it's founded properly. I'll explain your answer. Annexure 6 is the demand. Annexure 6 is the demand. Now, this assessment was done expired. This is directly covered by a judgment of this honorable court. Where incidentally, Marshal Justice Raman was the party for the judging. So, I'll tell you nothing why those documents would be necessary. Just to point out for your record, Para 53, page 53. Page 53. The volume of extraction of blackstone has been estimated by using global mapper software. Image RL height of the previous mining plan surveyed on 8/11/21. Satellite image is not available in this area during the period of October 2022. So October 2022 I was given the mine for the month of 6th June, October 2020. So there is no base here DM available to calculate the volume of this area, so that to take the previous year mining plan provided by the Synergy POC. And then minus the first page introduction. Raj,
You are
I'm a long 5 years. 5 years.
no, you are a subsequent lessee.
Smaller. You leave that earlier. I came in only in 22. In June 2020. So they do not have any records of what was actually the volume and what was available in June 2022.
No, prior thereto, there was already a lessee who was doing a mining activity
Yes.
there in the same mine.
Yes, so they have calculated from 2021.
That stone comes under the OMMC rules. And MMDR Act applies.
15 would apply. And
Why?
the rules have been framed.
Why not 8B?
Why not? Give the rules. Give that money. So there is this is big difference. The difference is
Twenty-six. 2026.
Malan.
Page 62.
Page 62.
Yes.
It is other than atomic, I believe.
Madam?
It is other than an atomic and all.
Yes. Madam. Page 62, yes, sir. These documents, detailed documents we had asked for, because they did not have so our technically, so, but examine it, we have to give them the right to examine, that is exactly what your lordship has held.
This is to accept that whether there is over extraction or not.
Yes. So, it can't proceed ex parte, it can't be one-sided determination. Unilaterally, they can't determine, they have to give us an opportunity. That is exactly what your lordship has held.
Don't you maintain the records of structure, not the production as is there in the act itself?
We mentioned.
So we release those documents.
We keep a record, our records are up to date, we keep a record, our records are up to
Well,
date.
you have to be uploaded every time, I think.
We have done that,
on that
we
portal.
don't complain about that. They say we did an ex parte measurement, where we have found out that you have extracted this one, this should have been the quantity you have extracted this. That's what they say. And we have clearly categorically stated,
Without issuing any notice.
so we will not notice, there is no record of our being issued any notice here. We have stated in our show cause, your lordship the kind for the itself reply, then there are.
That means that they have issued a show cause.
No, it's show cause, the measurement there is no show cause. It is submitted that the lessee was never intimated regarding assessment to be conducted in this leasehold area. And further, in absence of the lessee or any of his representatives, the act of conducting a measurement, finalizing the query to finalizing that the quantity of 15,101 0.936 cubic meters of black stone has been over extracted. Really extracted. So all the time asking of your lord, if you give me an opportunity. For its reason.
Under Annex 2, so are issued to that, madam.
No, what happened to this para 7?
There must be some basis, of an over extraction. What is the basis of an over extraction? Because the report reveals something else, you are contemplating something else. So if you do not give them an opportunity, straight away demand.
That, to that extent, that I have to take instruction.
You are reading of the
Yes, but he sought for certain material to compare whether your private assessment is
Para 7, page 62 minutes, and the SOCO's reply also, they have also.
basis of calculation, how you have arrived at that it is excess. So that you have to demonstrate.
Yes, ma'am.
So unless you compare with their statement, where is the comparison in the demand notice or demand which you have this improved letter, Annex 6? Is there anything spelled out?
Millet here at page 62 millet, that is 12/2026 millet, they have given.
Correct.
And millet, this demand notice on Annex 6 was issued on 6/12/2025.
So have you furnished that is not coming out forthcoming from this Annex 6? Despite your furnishing detail which he has sought for. Where is the comparative assessment
Millet,
to arrive at that conclusion?
that is not attached to the
So-
demand notice.
So that is important for any assessment or for any demand to sustain
Millet,
without reason.
let me take instruction millet for whether there was any comparative chart or not, because millet, this page 62 millet, that is submitted on after this demand notice is issued to them.
Second time we submitted.
Millet. To that extent, I would take instructions, short adjustment.
First one was 44, page 44. Immediately we gave a reply. 29/4/25. And this was the second one. And then we gave another rejoinder, gentle reminder. That was on 12/1/2008.
Is there any reasons recorded or a finding recorded in relation to a demand? Simply they have raised the demand,
They have
and a show cause notice was issued, but there is no adjudication of show cause.
Nothing. No adjudication.
Let's
Straight away the reminders.
why I am submitting Annex 6, page 6. Here one line is written, personal hearing conducted on 6/12/2025.
Correct.
I will take
Will
instruction.
you not give a reasons?
Will
Will you not give a reason that if
if there
you have
is
given a personal hearing, you have raised a particular issue? They have repudiated or they have dealt with those issues. Then it is not your duty to say that which one is correct and which one should be accepted.
it's our duty. We have to.
So why you are not doing it?
It is
Not
not
your administrative authorities are so reliant, providing the reasons that.
Is it not procedural exercise?
That's no.
Raising a demand, it is not a procedural exercise.
That's
If that be so, then third limb of principles of nationalism.
That's it, it's right. My predicament is that now it's 6/12/2025 notice it shows there is a personal hearing.
Sir, I understand. One line does not dispense with the importance of the natural justice. Simply writing one sentence is a farcical way of doing the things.
They might have passed.
Unless you record the reasons that yes, he has taken this defense is not tenable.
Let's say.
And then you raise the demand. Why is it tenable? Give a reason. This is not tenable.
Before issuing this demand notice, they might have passed a reason order. That's why.
Where is that order? That is not coming.
One of
That's why I said, see,
Yes.
you are hurting at second limb of principles of nationalism.
That has not been alluded to also in the
That
demand.
that is personal hearing. Third limb, where is the third limb? Second limb also, you have not spelled out whether you have communicated those details or whether that you are available with him and you have not given to him, or those were available in record and you have not utilized them for assessment. It is not your case.
That's why I bring for an
Also, government holds the field as far as our is concerned.
Takano, I think.
Takano.
You are.
I was arguing Orissa and Takano. Takano was.
That is relative.
Takano was even more explicit.
After Orix.
After Orix, Justice Chandra said even more.
When you are entrusted with the brief, you should read the brief and take an instruction from the authority. And if these are not really cooperating with you, then I can understand that.
What happened?
The difficulty is that is it not really augmenting the delay in disposal of those cases
May I submit
for this fringe matters?
May I submit one thing? Day before yesterday, I called to the authority. He has met with an accident. That's why he could not give the instruction. Otherwise, we have other cases we are ready.
That's
That's why I'm praying for that.
okay. And you see there said that nothing is done.
That's
You are thinking of the
next week.
yes. Next week you want? Next week you want?
No, 1 week. Next week holiday.
Item 7.
There is already an interim order or you want a, they will take care of that.
I want to leave to. I leave it here.
If anything happens, you just come and mention.
I leave it here last
No, you just come and mention the matter in the event it happens.
Friend undertake. Let me say.
Item 7.
The challenge is the annexure 9. Annexure 9 is a demand raised in section page 61 and 62. Lord, before I go to the merit of, I'll just apprise your lordship of the modalities, how it is.
The grade you reported at the time of a dispatch was
Dispatch.
54. Now,
While the surprise inspection was done, it was found to be of a higher grade. So the demand has been raised. So, my lord, I'll just give the statutory modalities, how it is to be carried out. Because
sample has to be taken and the testing has to be done.
there has to be 3 samples.
Correct.
One is
If you are aggrieved, then you can also
yes.
go for that.
That I have also raised that objection at the umpire sample, because what my sample says, and if the government laboratory sample varies, then the umpire sample should be verified. And that after the demand was raised, I gave my so-called the reply, and I also requested the umpire's sample to be verified. But that has not been done. If your lordships would just come to annexure, my lords, my representations, page 65. That the deputy director itself has, who has issued the demand notice, has mentioned.
Reanalysis of the umpire sample of the section.
Yes, but that has not yet been done. And since this due is pending and shown to be pending, the NDCC is not being granted and I am not able to do the dispatch.
Who is for the state?
It's IFA for the state. No.
Is it mandatory? I think it is mandatory under the 10.
7.
So if there is some the dissent or disparity in the laboratory test report conducted at your behest and conducted at their behest, then law says there should be an umpire sample and it has to be sent whatever the
Government level.
government level. No, you are not doing it.
It's here, my lord, only one fact before this, my lord. First focus notice was issued on 23/10/2024, my lord. Thereafter, petitioner had replied. In that reply, my lord, if I may refer to page number 55, my lord. 54 and last point number 7. 54, my lord.
Yes.
Whether the lessee is strictly following the terms and conditions of the mining lease or mentioned under so and so.
The sample was carried out.
Yes, my lord. The samples also drawn from the stacks by the concerned JMO for analysis as per the sampling method. The JMO has submitted the samples at the Kyunja laboratory for analysis. Next page, my lord. The SCLS at the time of the cross-checking joint sample collection has observed slight change in the grade, that is so and so. Against the upgradation, we are willing to pay the differential dues, that is royalty, DMF, NEFT against the same stack, my lords. And similarly, on the next page also, Annexure 823/11 to
No, this is the letter issued by you, my manager. Oh,
My manager.
Yes.
Next, Annexure 823/11/2024 also, at the last page, similar
Page.
page 60, my lord.
60.
This is second reply to the show cause, my lords, at page number 60.
Yes.
Same, against the upgradation of the SCS, if we are found guilty by the authority, we are willing to pay the differential amount.
That is what is the contingent one.
No, it's here in
In
this
the
case.
event if it is found that there is, then they say it's my statutory liability or the responsibility to pay, I pay. Is not, but they have not
They can't take
they have
away my right.
they have not abandoned their claim that it is not. What is the meaning of that? If we were found guilty by the authority, if that's a contingent one.
This letter did not.
That does not mean that he abandons his claim.
First letter did not have that, my lord.
What?
Page number 50 against the upgradation.
No,
Have they waived the right
No,
to
let's
get it
my only
re-verified?
so my only limited submission is that at that point of time,
you
they
wanted to take a advantage of waiver for acquisitions.
At
I
that-
understand,
at that
but if
point-
it is a conditional one and it's contingent as well, will you?
only my respectful submission was at that point of time, they could have asked for.
Defy the mandate of law. I'm just simply asking you a simple question. If the law says that in the event there is a disparity or an inconsistency in the reports, then an umpire sample will be drawn. It will be given to the government laboratory for its testing. Why will not adopt that? Either you delete the provision. You have a legislative power, you do it. But once you have incorporated, can you defer?
Here, the first SCDS analysis was done by government laboratory. Miles, I understand rule 10.7, Miles, I have gone through. Only thing is that.
It is only on a paper. This paper should never apply or never apply.
Here, the power has been given to the director, my lord. If he is satisfied with, if I may read my lord's 10.7, rule 10.7, if after
Satisfaction has to be
Yes,
reported in
ma'am.
writing.
yes, my lord.
Where is
On what basis?
Here, my lord, after
So
this,
there must be basis for the satisfaction.
yes, my lord. Yes, my lord. However, that has not been done as per my instruction, my lord. After this,
I'm just that's what we are asking.
that if it I
They have if they have gone to you say that I do not agree with the testing report. My laboratory's testing report is different. Have you submitted the testing laboratory report from your end?
Yes, Form K, yes. We have done that. All the parameters and everything, all the requirements we have met with. Because this was after the dispatch that they did the surprise check. Initial dispatch was permitted on the basis of my report. The inspection, they found that it is slightly higher grade.
Okay. We understand that if it is higher grade, they are liable.
Yeah.
There's no quarrel to that position. But you must follow the procedures of law.
yes, ma'am.
If you do not follow them, what?
It's here, the DGM had recommended for,
That is what he says,
Yes,
that
my
he
lord.
has recommended.
yes, ma'am.
Still,
However, I don't, my lords, as per my instructions, there has nothing been done after this, my lords.
how it can be sustained.
If I could just take an instruction from the director, if they have disposed of, because this is a very old matter, my lords. The demand is of 2024, my lords.
Even 26, we filed a representation on 10-3. Nothing has been done at least till date as far as
Yes, as per the record that we received.
So you want me now to change my view and start directing the representation to be disposed of.
However, the representation is pending.
Take instruction, give us whether on that basis you have done an analysis. Your instruction is that you have not done anything thereof.
Now, telephonically, this is what, but they will cross-check me because I have cross-checked from the DDM, but from the director's office, because director is the final authority who has to do it, my lords, under the rule 10.7, my lords. So I'll just cross-check from there if this has been done, my
Maybe
lords.
on next Monday,
Yes.
and then from as a specific month.
certain limitations from under Wednesday subjective also.
Something nice.
What limitations? There
Yeah,
is no inhibition nor the limitations. There's no
The personal inconvenience.
inconvenience personal, no. Or it is a collective inconvenience.
No members, not because of that. But then otherwise I would have taken it on myself. I would not have said his
It's Wednesday.
Yes.
DP.
Item number 8.
Yes, Your Lordship. Lordship, I am appearing virtually in this matter. Lordships, in this
Yes, who's for the?
Yes, Milot, I am
Who's
appearing
for the other side?
it is a statement.
Das, once the no objection has already been issued to him, can you raise a demand subsequently? While issuing a no due certificate or no objection, he has surrendered the query. Can you?
Well, its surrender of query has yet not yet accepted. That has not been finalized. That is only the bank guarantee which is.
No, the certification has been given that there is no outstanding dues.
Well, no outstanding dues for the financial year 23-24.
Yes.
But if your lordship will look at the demand that is free,
Is a subsequent year.
is the subsequent year 24-25 and 25-26.
If he has already surrendered and communicated his decision, then what?
But whether that decision, because the Tahsildar, the then Tahsildar has to accept it. What has happened? I'll have to take instruction. Whether it has
Milot,
been,
if
whether that surrender has been approved or not, my lord.
Milot, if I may apprise your lordship's Milot.
Yes, you have
Not
what?
operating.
Milot,
That is not.
Milot, if I may, with your lordship's permission.
2024, yes, surrendered.
Surrender. So,
Then thereafter is not operating.
No, Milot, it's not operating. We have already gone back.
It's not
Milot,
operating.
we have already the bank guarantee has already been refunded, Milot, and Milot, we have already surrendered. The bank guarantee has already been refunded in the month of April 2024, Milot.
Yes,
And it is subsequently, Milot, they have issued this demand notice for
No, I understand that I have read, that is what I'm saying. So bank guarantee you have also released. Is it not an afterthought? Then how you have released the bank guarantee if the surrender has not been accepted? Where you have stated the bank guarantee is.
Milot may have para 8, Milot, page 5.
Yes,
Milot, that
yes,
it is
paragraph
for-
8, very clearly said.
page 19 also. Because many officers has
Has given a no due certificate, no outstanding. I was thinking.
means he's notified everything.
Your lordships correctly pointed out, Milot, page 19 is Milot with regard to the release of bank guarantee itself. Because as per the letter of the Tahsildar, the mining officer, in reference to the
Mr.
release
Das,
of the
this,
bank guarantee.
these facts shows that.
Okay, on this matter on Monday in a supplementary list or on Wednesday in a supplementary list so that I can take instruction why they have. So that, but I find should not have been. Should not have been because once.
Mr. Das, if you read those averments,
Yes, I have.
he has very categorically said, you should
Yes.
have asked the officer that what is his reaction or what is his response.
And even the that is an annexure fee for lordship will find.
It pertains to 24, 25 and 25, 26. He says that if my closer plan has already been accepted in 24,
But that
I have been given all thing, every amount back, even including release of the bank guarantee. What remained?
that letter said also kept your query operation in idle, not generating e-passes since last 2 months.
Because he has already closed.
So Mr. Das, confusion arises here. Officer has said that there is no deal, right?
Yes.
For 23 up to 31 to
21, 3, 24, there is no.
next phase, it is deputy director. And last paragraph clinches against you. If you don't.
Lease has already surrendered, forfeiture has already taken place, money refunded, everything is done. What he's doing?
So your AI tool is not working properly. You depend on AI.
On Monday, my lord, only on Monday. Very bad. It's not available.
Keep it on Monday for those small purposes.
So I think just he's the just higher authority.
Is that yes.
Just above.
over and above mining officer.
Monday is a specific for taking instructions by Mr. Das.
Much obliged.
Item?
10, sir.
Nice.
The same point without complying with Rule 10(5) that umpire
Without complying,
Rule 10(5) of OMPT rules that umpire sampling.
10-7.
10(5) read with 7. 5 is the procedure how the samples are to be done.
Last time amendment was carried out, of the revisional authority, because they had approached the revisional authority and the revisional authority, the section officer of the revisional authority, without placing it before the competent authority, he simply remanded the matter, saying that we are not the competent authority to decide. That is what they categorically wanted to challenge, and they wanted that the matter should be, the accused order should be set aside and the matter be placed before the revisional authority. That is why the amendment was allowed. And they were directed that just now they are serving the amended petition copy.
It's a pure question. Kindly consider this. The demand was raised.
I understand.
That's the same as
Also appreciate the predicament of the state lawyer.
that copy was served on Friday.
They said that just now the composite, the amended writ petition is served.
And my instruction is served on Friday.
Online, he has got the hard copy today.
Today.
So that's why I said AI tool is not properly functioning.
Come on Monday, take instruction.
Yes, that's the point. That's what I was present.
I understood the moment you.
Order passed by the revisional authority, the
Understood.
council appearing for the central.
That's why he wanted to take instruction. Let him come. We know how to dispose of the matter immediately.
Correct.
Yes.
Let him take instruction.
Item number 12.
11th? What's your wrong? So not two Passover. It is a one Passover. Okay. Yes, next.
Item number 13.
2 weeks.
Item 14.
Record. Adjourn.
The extension of query is especially we see the paragraph 5.
Where is paragraph 5?
Page 4.
Gradually, I think administration will not
function. That's the time has come. What we perceive from the past, you will not be able to run the administration. It will be run by
excise mining, and this then this PI road work, contract tender, villagers. In most of villages, you don't know whether they are actually villagers or somebody.
You have to take a decision. You have approached them, they are not taking decision.
They have rejected. They have rejected my extension, my lord.
So now tell me, where is the provision for extension? I am asking you under the rules, statutory rules, where is the power for extensions? Sure. OMMC 2016 assures that there is a power for extension. Where is the power of extension? I can understand. Rule 8 you are saying, let us see rule 8.
For which prospecting license?
Just a minute. 8, yes.
Period for which prospecting license for mining lease and dwellings be granted for the specified minor minerals.
Yes, this is a specified minor minerals.
Yes, specified minor minerals.
Are you coming under that specified minor minerals? Tell us, where is the schedule? Please.
Page 112.
What is this is a sand?
You have stated that.
That is a sand?
Sand.
Yes, does it come under the specified minor minerals? There is a rule, a schedule which says which will come and which will not come.
Specified minor minerals has been defined by page 15 minor.
I am asking as in terms of the schedule. Where is the schedule to us?
It is that page 112.
Yes. Yes, schedule 2. Yes.
Materials have been not been.
Just, that is what I am saying. No, a specified minor minerals, decorative stone, except this. Yes, tell me, where is the sand coming within that?
Ordinary. Ordinary clay.
No, ordinary clay is a different. This is the sand.
Ordinary sand other than used for industrial purpose and pesticide purpose.
Which?
Ordinary.
Where?
Other than used for industrial and pesticide purpose.
Where it is?
It is followed at page 112, schedule 3, point number 2.
Schedule 2. Schedule 3 is not here.
Schedule 3
Yes. Correct. So what is the definition?
Under definition is specified minor mineral means minerals including decorative stones other than listed at serial number 2.
So schedule 3 is excluded from the
Schedule 3 is excluded
from the specified minor minerals. They are not coming under the specified minor minerals. Correct? How rule 8 applies because it applies to specified minor minerals.
stands other than used for industrial purpose or other.
I am asking you periods for which the prospective license or mining lease and a quarry lease be granted for a specified minor minerals. So it is only applicable to a specified minor minerals and not otherwise. So well, I do not know. Definition says other than, which is schedule 3, serial 2. Serial 2, you are saying ordinary clay.
Ordinary clay sand
Yes,
Other than you.
used
Yeah.
for
So it is double.
industrial and pesticide purpose.
So we not against that. I use other industrial purposes. Industrial purposes means where
Not operated for because of the.
where is your license? Where is your license? I am asking for what purposes the license is given. Show me in the lease whether it is only for industrial purposes, the site. Let us see. Page 20?
21, page 21.
Yes. Yes. Where is the specification, sir, that this you will use the sand only for industrial purposes? What is the stipulation in the lease deed, sir? Sure, sir. I do not find any of the terms which restrict. So, why not a ordinary sand? It is an ordinary sand.
I can use this from
No, sir. There must be a specification. You have to apply that. Give me a prospective license only for the purpose of utilizing it in the industrial, in the industries. That's all. No, sir. Take your time, but it cannot be done.
Dear my machine, there's no special for what purpose I will release.
That should be because that is what is the mean. It says the period for which the prospective license come mining lease, and quarry lease be granted for specified minor minerals. Now you have taken us to schedule the definition. It says that all the specified minor minerals was coming under Schedule 3. Schedule 3 ordinary stand is excluded from the specified minor minerals. Correct? Again, an exception is carved out that if it is used for industrial purposes, then it is not excluded. It will be within the minor mineral, the specified minor minerals. Correct? Then you have to show that it is prospective licenses for utilization in the industry, not otherwise.
Actually, bad me for using this as in
Then you cannot take an exception.
can use this very easily. Thanks for industrial purpose.
Only used for other than. Then what is the meaning of the word? Other than. Tell us. Is a double meaning. Please read. Is a double meaning. Ordinary clay served ordinary sand. So Schedule 3 is excluded from specified minor mineral. They are not specified minor mineral. Correct? Now then it says after the sand, then used for industrial and prescribed purposes. Prescribed means must be immediately indicated in the lease, indicated in the license, that this license is granted for a quarry, the sand to be utilized only for these purposes.
I have to go to that lease agreement.
You have said, now we have not all the terms and conditions not specified. Only prohibitions are there. You cannot go within this width. You cannot go deep. You cannot do this. Everything they have done. So you use it. Then very interesting, sir. Then very interesting. Then every quarry lease is coming under the specified minor minerals. Every lease. Sir, again I am saying you should talk law. Show me the provision in the rules or the statute which permits the renewal or extension of time. That's my first query. You said that rule 8, but rule 8 has a restrictive applicability. Show me that you come within the purview of rule 8. You have not been able to show any document. Mere assertion will not do.
Yeah, another point is whether I was not allowed to operate because of.
Then very, very interesting. Then I say lease is granted, treating the land as a homestead land. In a portion of the homestead land, you do say the gardening. You do an agricultural purposes. Use it. You will say there is nothing which prevents me. I have been doing it agriculture. It is an agriculture. Is an agriculture land. I don't.
Enter building will also come.
Sir, agriculture. It's all for agriculture purpose because I am stocking the produce of this agriculture in my house. So it's agriculture. Very interesting arguments are being advanced. Sir, when it says the specified purposes, then there must be a stipulation in the lease deed itself that you are permitted to do a query or to be utilized only for industrial purposes. You cannot sell it in the open market. If it is general, then it is general for all purposes. You can sell it to an individual, you can sell it to a wholesaler, you can sell it to industry, you can sell it to anybody. But that does not mean it is a specified purpose. A prescribed purpose. Actually, the word is prescribed purposes.
There will be some final. Just another minor 9 points. I was not allowed for 1 year because of one PIL was filed. Then there was extension by the villagers, and because of that, PIL inquiry was conducted, and the inquiry was found that the allegation leveled by the villagers are not true, my lord. For that purpose, I also paid, my lord, the royalty and for everything.
We have already held that it has to be refunded with interest. Our view. We have taken that if there is no provision, whatever you have collected, you'll have to return because there was no fault attributed to your conduct. So in that event, they have to. That will do. There is that order of refund. Pratap, Ishur Mohanty. That is the NGT matter.
Great.
Kumar, oh, it is Kishore, such a Pratap. Oh, this is a NGT matter. We have said so. Yeah. It was a force majeure in pandemic, but it is not a case of a pandemic.
The collector also recorded our finding. At Route 64, you could have adhered to.
It is only the government who can do it. 64.
You said not declared, but not included in specified manner. So Rule 64 is the power of the government to regulate the reserving cases as deemed. So you should have approach the government. The same thing.
Where we have said 64. That's the only power which is given to the state government to relax the rules. Otherwise, you can't. And he is correct, it is not coming under the specified minor minerals. Should we deliver a judgment in this? Because we wanted to, because there are a lot of confusion in the mind of the litigant. It's not. What time? It is applicable to a specified. Come on Friday, come ready. Skip it on Friday. Oh, as a book is. Let him ponder upon the things, but yes, call the next.
Item 15.
In this case, I was bringing relaxation of rule 27(7), so for the bank guarantee, Lordship, I want to give bank guarantee. But in the meantime, Lordship, I have deposited the entire amount. Let it be some other day so that I can, Lordship, advance my argument.
Monday.
Yes.
Item number 16.
Next matter.
in judgment of this, where you are also this the finding in the judge specifying a particular date as a commencement of the lease.
Commencement of the lease period on the date of agreement, yes.
So can you now at this stage go back, set the clock and
No, there is no such 71 date.
correct?
Our case is, this is a non-existent date. That is what we wanted to show you and we have shown to your article. It's a non-existent date. And by showing that in Annexure 18, it has been stated that will not improve this case.
Only one thing my senior is pointing out that without going to merit of the case, only one point is happening.
Just remember, I think there was one fact which we are arguing. Since 71, it has gone into several changes.
Yes, Milord.
And then I think the sale or somebody who was there
It is a
for a certain period,
Yes.
thereafter surrendered.
Yes.
And then after the surrender was done,
Remember.
the surrender was done, and in that event, the fresh
Yes.
lease was granted to you.
Yes.
So now, if we go here with the civil law,
Yes.
if there was an existing lease, if the lease is surrendered,
Yes.
can the continuity be still maintained when the lease itself is surrendered?
No, surrender by virtue of law.
Oh, never.
Yes.
So the lease has come to an end. Now there will be a fresh lease.
Yes. Because they reserved it virtue of law, section 17A of the MMDR Act. Then they have given to the Steel Authority of India. Then Steel Authority of India surrendered it. Then it is accepted. 10 million in 91, which effect 96, which effect from 91, it was granted. So therefore, 71 is a non-existent date. There is no such. It is absolutely, there is no basis for 71. It is an imaginary date, Milord. That's what my case. And that Milord, 2 paragraph of judgment.
This was never the case before the state authority, neither in the revisionary court.
One line, if it is really a declaration of law sufficient, why law is to be stated in 100 lines?
No.
Or it can be stated in one line.
Milord, that is always Milord hallmark of a good judge. Yes.
That's why I always think of reading the privy councils that 3 paragraphs, 2 paragraphs.
My whole thing is there are several disputed questions of facts involved here. And magistrate, may I comment? You also kindly keep a glance to Annexure 18. Annexure 18, all these things have been stated there in elaborate.
I am asking the pure question of law. Everything you may have stated.
You are asking me a question which is based on facts.
That it is sacrosanct. You have to justify.
Yes.
The thing is that suppose there was already a lease in the year 1970.
Yes.
Then what happened? And what is the effect of that particular lease?
I
The
understand.
question is, again, I am into the civil law.
Yes.
A lease was there.
Yes.
The lessees there may be an assignment of a leasehold right into a lessees. That assignment I understand.
Yes.
That means so far as the period of lease is concerned, the assignee will be continuing under the same terms and conditions which was there in the original lease. But if the lessee subsequently surrenders the lease,
No question of surrendering here. He has not surrendered. Not surrender. No.
under the Transfer of Property Act, if the surrender is done, now the surrender envisages 2 consent. One is an intention to abandon, not to continue. Second thing is parting of the possession or giving up of the possession to the lessor. Once the lessor accepts the possession from the lessee and the intention is complete, then in that event, if the lessor further grants, is it an assignment of a lease or a fresh lease?
Here is a lease which is continued for 20 years from 24/10/1971 for 20 years. Before completion of 20 years, he has to make an application for renewal of mining lease. before 1 year he has applied. So it is a continuation. It is not that he has surrendered or something. It is a continuation process.
No, this is what saying.
No, he is not saying correct thing. He is
Surrender
correct.
the lease.
Not correct. It is not correct. It is not no question of surrendering. Renewal application is to be made before expiry of the 1 year of the
That's
period
an
of lease.
option of renewal to be exercised. I understand.
No option.
That I have done.
That he has done. So question of surrendering.
That this still has surrendered. The
No, not
where,
at all.
where do I get
No.
surrender?
Kindly read below page 120.
Where is the
All these things which is
Page
all these things which is now raised before your lordship is never raised before the
Sir, no, please come to para 2 of impugner.
yes, exactly.
The learned counsel for the revisionist.
No, revision stock is
They were not given any show cause notice and expert order was passed. You
it
have
will
not,
appear.
you against that para 2.
Yes.
You have not dealt with any. As a revisional authority, you have not seen the record. You have not dealt with any. You have not brought out any finding. Para 3, first line.
Yes.
The learned counsel for the state government states that the lease was granted on soil.
Sir, with deepest of respect and the humility in my command,
Yes.
sir, what you say is not correct. I think the office of the regional chief conservator of forest is your authority, I believe so, statutory authority.
Yes.
Come to page 121, the first paragraph. Come. First paragraph, at the top, category 1. You say not, sir, please read. It is not they are saying, it is what the authority is saying.
Sir, sorry,
Not legible.
First paragraph.
subsequently,
First paragraph, sir, page 121.
Subsequently, Srimati.
it is the clear.
Yes, sir.
Computer page 149 but the secretary clear as well. Computer page 149.
I have not received any instruction in the matter. Whatever I am submitting on the basis of the impugned order.
I understand that you are a creature of the instructions, but you are first the responsible officer of the court. If the cost or pleadings have been given to you, I believe, and still believe that whoever appears on behalf of the litigant, he reads the brief and then argues. If something is written and it is not that they are contending, if they are contending their version, I can understand, you can dispute it, you can repudiate it. But if the authorities have accepted and recorded, can you, whether the authority can say it is not correct? With all humility, I do not think
What
that
will
it is
office
proper,
say?
sir.
What will office go down to the accusers? I have no
So
problem.
you will not, we expect that the members of the bar comes and argues after reading whole of the brief. Because I still believe whatever is stated at the bar when they say, I always take it that they are saying it with responsibilities and within the records, not beyond the records. when a senior is saying that, yes, it is a surrender, then he must have read it, and then why he stood for. And you say not surrender, renewal, option for renewal, no surrender. Without your own authority says surrender, you are saying no surrender.
That is a wrong recording here.
And the division of authority,
Yes. No.
Not.
since he has not recorded this independent finding.
No, there is no finding. There is no.
That is why Mr. Maya stands.
Yes, talked about the earlier judgment, in reference of the earlier judgment.
The earlier judgment.
No. It's not discussed. No, that's what I'm saying. Regional authority has discussed the earlier judgment.
He has not taken note of earlier judgment also.
Yes, that is what I am saying. The earlier judgment says something factually different than this.
No, that has not been given effect. That is what Mr. Mahathir said, isn't it?
If that is so, I have no
We are taking
different.
advantage of the earlier judgment. Passed
121.
in this matter.
Yes.
If the court, you have not challenged that order of this court for the High Court, nor you have applied for a review. So that is binding on you. Even if factual in the accuracy is doubtful, still it is sacrosanct. You can't dispute what has been recorded in the judicial order. Even by affidavit, you cannot do it.
I don't know.
State of Maharashtra is A.R. Anture or Ramdas Srinivas Nayak. Probably AIR 1982 Supreme Court, page 1347 or 1437. Find out. In strong words, the Supreme Court has said that you cannot dispute what has been recorded in the judicial order.
And this document is also applicable to 14. Conservator of forest. That is after decision of this court. That observation of conservator of forests came up in 2014 after judgment. This judgment is 2020. This is 2014. So this contemporaneous document speaks for us. Unless some variation of Europe that
The proceedings under answer 18, he has not applicable. The expertise order has been passed. That's why the under challenge. That, yes,
before the Vishnu Authority
appear. But that there is
has not recorded
anything. So I am not on that. Regional authority, I don't support that.
So we are setting aside and relegating it back.
Yes, exactly. That is what my submission is. That will relegate back to the authority. So that's yes, that is what my submission and the submission was there.
Yes.
Without explaining, university में class है press. University में class है press. Without
Siddharth से पहले. Item number 17.
So as this 20% ignition in the mining. That is what I do not know, because I believe that this matter was taken up by us. Yes. And that was arguing. As my brother and me, both of us, because the arguments are advanced without looking. Then I found that there was certain plea which was taken there in the revisional application itself. And then thereafter, nothing was considered, no argument was advanced. So I just wanted to know what is the effect of that. Because I find it was a plea which was taken. Is it sacrosanct? It is not sacrosanct. The binding or not binding? I just wanted to know.
So, may my lord, since I was not aware what your lordship wanted and Miss Radford.
No, it was, I tell you, if you come to the impugned order,
Yes.
you were arguing that if any explanation is appended thereto, then in agreement, this explanation is clarificatory in nature and as per the interpretative tools
Yes.
or interpretation, it is always retrospective, not a prospective. That was the only argument which was advanced before. But while going papers and considering that, we find that certain pleas were taken on facts.
But so far as that imprint deviation, the mining plan is concerned, my lord, that your lordship will find.
No, which I tell you why I just thought, because it was not argued even before us.
Yes,
It was not argued.
but it
before
was
us.
argued before the revisional authority, my lord.
It was not even argued.
Not even argued, only.
But
It formed
the
part of
original
the
application
ED.
contains many factual aspects.
Yes.
So the counsel who was appearing, he said,
Miss Radford was hearing that.
I think she said that, no, we argued. I said, no, if it is not reflected, I will not take it. It is argued.
It may be in the PD, but may not have been argued before.
That is what I was thinking. So, because I find from the common cause also, there was a reference
To that.
Para
That is what
136.
I understood. That
Yes.
is what I just wanted to know.
Yes.
Because the justice is paramount and will not be decided on the basis of some kind of a, the technical this thing. So what I find from the common cause judgment, I'm telling you, expressing my mind, which is playing in my mind, so that at least you get it. What I find was that there was a reference. The reference was that the IP, if I correctly remember IPL, he suggested that if there is a variation to the extent of 10%, then it is permissible.
20%. It's 2003.
Then I have read now,
All right.
I recollect everything. That was in the common cause, it was gone. Then subsequently, they increased it to 20%. They learned it. The Supreme Court, after noticing, simply make one line. It says, I do not find any rational or a reason for enhancement from 10 to 20%. That's an observation in the common cause.
But para 136.
I know, that is what it says.
Not one line observation, there is a whole paragraph dealing with that.
No, that is a reflection of the facts. I find one line, it says, I do not find. And then thereafter, there is no discussion or reference on this particular aspect in the common cause. Ultimately, it was that the mining plan is sacrosanct, which yesterday also we have heard. Yes, that it can't be a mere technical document that was argued. It is sacrosanct because of the common cause as well as the different provisions of the MMDR Act and the rules. So that is what I see. The mining plan is there. IBM is constituted by virtue of an amendment brought in the MMD. So their authority is also given for certain things. So what would be the effect? Because I find that common cause has not really dealt with in those lines and discarded. We have no authority. Not discarded. Simply one line. If you give me that judgment, that portion of the judgment, you will find.
Kindly have a glance to 136 because it deals with the submission as well as the answer given by the Supreme Court.
That's what I'm coming. So I just thought that if you think of then let us see, because this appears to be a gray area.
Yes, ma'am.
Where there is no clear cut
observations that has
In the
come.
present case, my lord, there is a violation of the mining plan, so also the EC.
Understood. That's why I'm thinking of.
Para 136 if your lordship may kindly see, page 555.
This is what the Supreme Court say, a side issue.
Yes.
It is not a main issue.
It is issue.
It is a side issue raised by the Learned Council for the mining lease holder. In this regard was a necessity of adhering to the annual plan or the calendar plan of mining. It was contended that the mining lease holder could mine in excess of an annual plan. While it is so, this submission must be tempered and appreciated in the proper context. That is what it says.
Yes.
A mining class is valid for a period of 5 years, but there would be a 20% variation in extraction over and above the mining plan. This is the maximum that is stated to be reasonably permissible according to the in terms of Rule 22.5 of NCR. The mining plans have incorporated a tentative scheme of mining, an annual program and plan for excavation from year to year for 5 years. At best, there could be a variation in extraction of 20% in each given year, but this would be subject to the overall mining plan limit of a variation of 20% over 5 years.
But the next one is important.
That is what this means is the mining leaseholder cannot extract the 5 years quantity with a variation of 20%
in 1 year.
In 1 or 2 years. That means what it says is, suppose if it says that 100 ton,
Yes.
variation of 20%, 100 tons on a pro rata basis for 5 years.
5 years.
So 120 tons for 5 years is permissible, as it appears permissible, but spanning over to 5 years. You cannot extract in the first year
The entire 20%.
where 400 say the entire 20% and then say I have exhausted. That is what's not given.
Right.
I understand. That is what I'm coming to it. Then where is the gray area again? In 1 or 2 years old, the extraction has to be staggered and continued over a period of 5 years. If any other interpretation is given, please, it would lead to an absurd situation where the mining leaseholder could extract the entire permissible quantity under the mining plan plus 20% in 1 year, and they extract minuscule amounts over the remaining 4 years. And this could be done without reference to EC. The submission of the learned in this regard simply cannot be accepted. This is what I was stuck up. What does it mean?
But the submission.
Does it mean that the entire submissions which is recorded previously is not accepted? Or only to the extent that it has to over around 5 years cannot be done in 1 year or 2 years? In the next paragraph, very interesting. In the letter dated such and such sent by the Secretary, Ministry of Mines and such and such, concerning the violation of the annual production limit laid down in the approved mining plan, it was stated that an analysis of the production and violation of 104 mining leases for bulk minerals in the last 10 years was undertaken by the Indian Bureau of Mines. It was noticed that 71 cases there was an excess ore produced beyond the reasonable variation limit of 20% above. It was noted that this was partly due to the failure of the state machinery to the movement of minerals. In a further letter of such and such, it was reiterated that any violation of the mining plan or the mining scheme noticed by the state government should be immediately brought to the notice of the IBM to initiate a suitable action. It was reiterated that transit pass to such mines could not be issued to the state government so as to stop any additional outgo. It was added. Then it was said. It is quite clear from the correspondence placed before us that as far as the Union of India is concerned, any violation of the requirement of the law has to be formally dealt with. With the reference to interpretation, then it says within or outside. So this is what I was stuck up with. And it is also preceded by one more thing, I did. It is also preceded by paragraph. If you come to 120, I believe, 19 and 20. 120. Sorry, 119. This is what really It starts from 1992. If you see 19, in a subsequent letter, to the Chief Secretary of Orissa, Government of Orissa and Ministry of Mines noted that there was a violation of the actual production limit laid down in the mining plan. And the state government has finally taken up to curb the illegal mining with respect of overproduction of minerals. There was a reference to suggest, and we take it to be so, that 20% deviation from the mining plan in terms of the overproduction would be reasonable and permissible. However, it appears from the reading of the communication that illegal mining was going on. 20% deviation limit, and that appropriate steps were needed to curb this violation. The Learned Counsel for the Petitioner submitted that such egregious violation must be formally dealt with by cancellation or termination of the mining lease. Soft approach is not common. In this context, there is a very interesting this one. It is worth noting that a high-level committee on a national mineral policy noted in the report, then it says, an EMP has to be under the such and such got approved from IBM. However, EMP is not acceptable to MOA. The miner has to prepare two EMPs separately, one for IBM and another for MOA. The committee suggests that IBM and MOA must prepare a guideline for composite EMP so that IBM can approve the same in consultation with MOA or field officer. This will eliminate anomalous situations where increase of even a few tons in production requires project authorities to get a fresh EMP approved from MOA, although the IBM allows a grace of plus minus 10%. Keeping in view the market situation and process complexity, if a single EMP is accepted in principle, such anomalies can be resolved in advance. The committee feels MOE should have the cushion of plus minus 10% in production by giving an EIA clearance. The above passage indicates that the permissible variation in production as per the IBM is plus minus 10%. But according to the letter dated 12/2011 issued by the Ministry of Mines, the reasonable variation limit could be plus minus 20%. It is not clear. This is what the gray area I got confused. It is not clear why in variation. But as rightly pointed out by the Learned Counsel for the Petitioner, the fact that in some cases the variation exceeds 20% was a cause for concern with necessitated strict and punitive action. This is where I was stuck on.
So 10 to 20% reasoning
Says that-
has been given, but it has been
There
permitted.
is no reasons I am correct.
But it has been permitted.
That's true. It has to span over entire 5 years. It cannot be done in one. So, but this was not argued that whether the authorities have taken note of this variation or not. That is what I was.
If your lordship may kindly see, I have given that instruction that I have received from the department, Steel and Mines. So the revisional authority is the central government. So the order passed by the revisional authority is the central government. But so far as my instruction goes, so lordship, they have referred to this particular paragraph of the common cause judgment so far as 20% interim deviation. And if your lordship will find in a column form, it has been given how there is an EC violation because EC was for a particular period. Then the EC was reviewed and my lord, enhancement of TPA to 1.5 million was allowed. Now with that allowing, if your lordship will find in the common cause judgment at page 561, what it says, your lordship make calculations on merits so far as EC violation. Page 561, if your lordship may kindly come. 561. Page 561, para 155.
Yes.
May I take your lordship to B, the admissible production for a year in which the environmental strength for the first time has been considered on pro rata basis of A, the prescribed annual production, and B, the date of grant of the environment clearance. For this purpose, the environmental clearance granted on or before.
No, please. This is the method of, I have seen that. This is the method of calculation.
Yes.
That I have seen. It was in the month of July, if I correctly remember.
Yes.
So it says that if it is before in June, then in that event, it will be considered in that way this month.
Yes.
On a pro rata basis, on a monthly basis, it has to be done. The question is again, I'm telling you, what is the purpose of this variation? The variation means if it is permissible 20% variation, then you will have to give a buffer to the extent of a 20% variation on that basis itself, on a pro rata basis.
Well, a 20% variation so far as the mining plan is concerned. But EC limits.
What I was thinking that I do not know the 20 because it says so that if the mining plan is getting reduced, then what is the meaning of this variation, permissible variation? Permissible variation, whenever it is given, means that it will be within the purview of the sanctioned or approved mining plan. Because this variation is permitted. I do not know, Mr. Nando, how he will.
No, that is true, man. That's how.
Then what is the purpose of permissible variation?
Well,
Then it has to be treated as any kind of a violation, but it will be within.
Well, permissible variation so far as the mining plan is concerned.
Correct.
But so far as EC limits are concerned, here it is also a case of violation of the EC limits. And how there is a violation, if your lordship may kindly have a glance to this tabular form, which is given in a detail in this instruction.
That is why the court has said that IBM and MOEF. MOEF means environmental.
Yes. And that is also as per the statute and the EIU.
They give the EC. Now, what is the effect of it? If
now, whether the mining plan will take a precedence over the EC or the EC has to take a precedence over the mining plan.
Plan is sacrosanct in common cause. It says sacrosanct. EC is mandatory. It also says EC is mandatory. Can a EC be granted for say 5 tons when the mining plan says 10 tons? 10 tons. I'm asking this question. What will happen? Suppose the mining plan says 10 ton per month. EC says 5 ton per month. Which must prevail? So, Nando, we are still in a state of confusion. I tell you very frankly.
No, we'll
go by the.
No, my lord.
We just wanted to know.
We'll clarify on those issues because I also need to know what is in your lordship's mind because first time I am appearing in this matter, so I want to know.
Yes.
Para 129. Also may kindly see. Make assessment. The simple reason for not accepting this interpretation in Rule 2 Roman 2A of the MCR was inserted by notification dated so and so. While we are concerned with the earlier period, that apart, as mentioned above, the holder of the mining lease is required to be adhere to the terms of the mining scheme, the mining plan and the mining lease, as well as the statutes such as EPA, the FCA, the Water and Prevention Control Act, the Air Prevention Control Pollution Act 1981. If any mining operation, this line is important, if any mining operation is conducted in violation of any of these requirements, then the mining of operation is illegal and unlawful.
What is the problem? I tell you, any of these, suppose there are, because it held that no mining operation can be done without a mining plan.
Mining plan. Yes, that is correct.
There is
Even
no-
somebody has a mining plan and has no issue, that is also not.
Says that yes, the mining plan is sacrosanct without which you can't do it. But apart from the same, you have also to see that the ecological imbalance is not created. And for that, the court has said that the environmental clearance EC is also very essential. If there is any violation of the EC also, it will attract the penalty and it will tantamount to an illegal extraction of the
consent to operate also.
There's no difficulty. That is what I'm saying. Now, suppose if there is some kind of a disharmony between the mining plan and the EC, then the question is that what should be the parameters of doing so? Problem is this: if no extraction can be done without mining plan, then also I'm just looking at it. If there is a difference, then what will happen? This is not answered here.
That is
Which really troubles me.
although we have
I
said
know,
mining plan is subordinate to EC, but
I at times invite trouble for myself also. Raising a point. But really, in the shape of evolution of law, nothing. If something is going in my mind, I think certainty in law or a uniformity in law is the paramount thing.
that's what I
It can
pray.
happen in future. It's not a one solitary case. Different also.
But what I pray, so far as the state is concerned, although state was a party before the revisional authority, however, they have not included state of Odisha as a party to the present writ petition. Let them include the state of Odisha as a party to this file or counter.
But you are representing.
But I am representing, but I will have
It's a
to.
pure question of law.
Yes, ma'am.
There, Mr. Das.
Because I will have to.
If this paragraph is to be accepted, where we are stuck up,
Yes.
where we are stuck up, this variation, if it is permissible, then if they are within that variation in terms of those observations,
But the
whether they will be penalized for that. Anything which is beyond, if they have done it, definitely there is no doubt in anybody's mind. There is no doubt, even in my mind also,
but if the
that they
variation
are
would have
liable to
been,
pay. They are liable to pay. They will pay.
but if the variation would have been within 20% and
Correct.
over the 5 years,
So it's true. That is what I'm saying.
that is also not the case. Also, there is a violation of
what
this.
their case is. That is what the case is.
Not over the 5 years.
Oh, over the 5 years, then
That is the
something is to be decided. Over
Yes.
the 5 years, then it is over the 5 years. And those have to be broken in that form. If it is in that way, then why at least some amount which they are entitled to.
So what I pray with, but since the mining officer is a party to the proceeding, your Lordship may allow me, as per the instruction, let me file one affidavit so that your Lordship may
What
can
is the
decide.
affidavit? It's a pure question of law.
Yes,
What
ma'am.
affidavit
I
you will
have
find,
understood,
Mr. Das?
For the satisfaction of the department, my lord, I have received the
There is
instruction. for
no
that.
quarrel on the proposition that you cannot charge them for extracting beyond the mining plan. No confusion. You will definitely charge them.
But here the extraction has also been made in violation of the EC manual.
No, not the pure question. Suppose, that's why I put a question. If mining plan says 10 metric ton, EC gave 5, which would be?
But the
common cause talks about EC and FC, I know. But this answer has not been given. There are two authorities who are working in tandem. One is an IBM. Systematic, all the scientific things have to be gone into while ascertaining that what should be the mining. And then the EC aspect that how to do the mining, keeping that ecological balance.
and they also provide a permissible limit.
Now, the question is if there is a variance, then which should do it?
Or if there is a overlapping, you can say.
That's a pure question. You understood this?
Yes, yes. We'll get back on it.
This is what it troubles. Do not know.
But in the meantime, also let them, why I'm framing matter, because since state was a party before the revisional authority, they are challenging the revisional authority. Let them complete so that we can file a counter and decide.
State Steel and Mines Department.
All right. We will serve an extra copy.
Yeah.
By oral prayer, it can be done.
We can sue about
Yes, yes.
whatever do they do.
Your Lordship.
That sue about the power is with us.
No.
Union, you are
I'm
representing, Mr. Maran? Union? You are representing?
Yes.
You are representing here. You have filed and you have not.
No, the reply is to.
clarification,
Consider or not
we are
consider this.
ready and willing to deposit 10% of the demand also if required, subject to your lordship to show our bona fide. Because otherwise the entire transaction, as your lordship knows, everything has been put to a standstill.
Come on, Monday, November. Weekend, enjoy the weekend for this. You also think about it.
But can it be on
It's
first?
a very interesting, I tell you,
Yes.
very interesting law. That's why I really.
But can I pray on Thursday in the supplementary? Thursday.
Don't Thursday.
Especially when both are central acts, then also the constitutional provision has to be gone into our work.
Anyhow,
We'll try to.
my mind, otherwise.
Definitely, my lord, we'll try to clarify the issues, whatever level best to our business.
Item number 18.
You have a founder has been served on the.
In fact, they have advocated all aspects in accepting one that 33(5) says it is not functional for 6 months, so it's to cancel. That is what it is. So there's no point in giving the presenter because there is no dispute to my assertion.
Is it?
Actually, my husband mentioned the regulation is correct. With respect to the executive basically was granted for 5 years but executed for 1 year, my God. So as per Group 8(4), so minimum is 5 years. But executed, is executed.
How can it, if the minimum cap is given, then you will do it.
That's what has been done in the law.
Say in the previous section 302, it says life, minimum is the life or the death. Can you reduce it for 10 years or 15 years?
When it refers to addiction on the lease, it mentions that the lease is valid for 1 year, but on the next page it is mentioned it is valid for 5 years.
So,
And as per Rule 8(4), minimum period is 5 years, and that is the basis of consideration in the entire matter by the mining officer member. And
what you're doing, if it is the statute says 5 years, how can you reduce this to?
thereafter they have not functioned unless after the period of.
It says that since it expires after 1 year, then what they will do?
And
If they do it, then you will penalize them. If they do not do it, then also you will penalize them.
already better.
And now the demand notices were issued
It
and
is a catch-22 situation.
yes,
If they go beyond 1 year, then you will interpret it is for 1 year violation. If they stop at 1 year, then you say, no, it is for 5 years, you have violated. In both ways,
Some out of 5 year tenure have only functioned for 55 days. Now they have settled 4 year, 24% interest and OPTR Act.
now they have
So-
not instituted OPDR mandals.
Sold up OPTR.
Because of the demand mandals, the factually mandals, I am not disputing mandals. This executed.
All my
for
bank
1 year,
guarantee,
mandals,
everything's
but
proper.
have been executed for 5 years, and because the rule says 5 years, mining officer has accordingly proceeded and raised the demands.
He himself is writing renew the EC in his favor.
Yes.
Very same day he is imposing cost. Demanding so-called of everything.
that has to be quashed. It has to be quashed.
The one thing is that kind of showcase notices were issued, so no reply was given by the petitioner mandal.
What you will do? If it is a pure question of law, if it appears that the initial period which you have enshrined is wrong, then what?
That those aspects could have been brought to the notice because now termination is also challenged.
So you can file your counter affidavit for more aspect will be brought to your notice. You have taken a decision. This is what your conscious decision is. Can your officer detract from this affidavit? So
The submission, this is also mentioned in our counter affidavit. There was no reply to the focus notice, personal hearing.
Now,
and
if there is a per se legality to a statutory provision, what more? Factual, we can say that since you are not filed, factually, we cannot say that you are wrong. But it's a pure question of law. They are relying on your own document, they are relying on your own thing, and then say that you are wrong. Rule 33, 5. 2016 rules.
Yes, sir.
This is a cancellation.
Yes.
For 6 months.
Yes.
And where is the provision for 5 years? Minimum.
8 course.
8 course.
Provided the minimum period for which any lease may be granted shall be 5 years.
Is it a specified minor minerals?
Stand.
Does it come?
Sorry, stone quarry. Wait partner.
Comes
Minor minerals.
with a specified minor minerals, not a minor minerals.
Schedule 3.
Schedule 3. What is this?
Entry number 0.2 service rooms.
This is what is this? What is the stone? Black stone. Huh?
Laterite stone minor.
Yes,
Laterite stone
laterite. Laterite is coming under the schedule 2.
minor.
So it does not come under the specified mineral definition. Oh, other than all the minor minerals, including decorative stone.
Other than.
So they are the- other than the is a white. So they are coming under schedule 2 also. And number 20. 24. That is the sandstone. Okay, this is a sandstone.
Sandstone.
And this is serial number 20 of the schedule 2 or serial number 34.
34.
Huh?
34 in shape of sandstone. There is a qualification.
Sandstone, laterite, and slate.
In shape of slabs and tiles. That is what I-
In shape
So
of
that's
slabs.
qualified.
Your is slabs.
Slab.
Oh, then it comes under 34. But laterite also in serial number 20.
20.
Also in schedule 3.
And also in schedule 3,
Schedule 3,
2, which has been excluded from the specified minor minerals.
minerals. It does not contain laterite.
It is there, minor. Laterite slabs.
Where? Oh, yes.
Schedule 3. Laterite slabs is there.
So, sir, if it is excluded, then how would it applies?
The tenure.
Asking for extension minus, they're asking, first, you have terminated their lease, they're challenging that minus, and the demand notices are challenged.
Demand notice is issued under what?
33 minus.
33. No, I was just thinking of 5 years period from where you got it.
It's 8-4 only talks.
8.4 talks about these particulars. I'm just thinking of.
This is the only provision which mentions the period of these minors.
There is no query, there is already a, for query purposes, there is a specific chapter or a part.
Chapter 4 minors.
Starting from which is
27.
Eight. So even if it is 1 year, he has not violated anything within 1 year. What is done, that is stop the operation and thereafter he has not done it. For that period, they have charged.
Beyond that, neither the EC was renewed in my favor as requested by Tahsildar, and after the total operation transfer to mining department, it was time and again requested by the mining officer to renew the lease so that he can operate. And they have also granted a certificate about the operational period, which indicates to be very precise manner is the mining officer himself says that it is non-operational because of this aspect. It's his own document matter. It's 58 may kindly be stated. Status of Kori operation. And we operated from 1st February 22 to 31st March 2022. 55 days.
Give it. For August.
I have also paid for the consequence that release of the bank.
No, see, if we release and all the deposit or whatever that has to be funded, then let us see what can.
I have, much prior to that, I have given surrender because it was not been extended granted from
So they are. Next week for orders, we have. But if you want, time for them. Item number 39 block yesterday also and 90 block. I'm not asking for any block. If not, some decisions can be given. Let us see.
It is submitted by the state that the issue
the present case and the case present lying before my justice court. So now I will wait till the battery is hard by Honorable. So thereby I am deprived of my admission. Either the whole wants to go or may not. Let us see. We'll see to it. Yes.
Lordships, I may be pardoned to mention your Lordships, I am through virtual mode.
Why?
Lordships,
What is that one? 62.
Lordships, may I be pardoned to mention your Lordships.
Item 62, sir.
What is this?
Well, this is a matter which your lordships had fixed for hearing, my lords. This relates to, my lords, the telemedicine policy of the government, which had come pursuant to a PPP mode, my lords, wherein health was also one of the sectors involved in the PPP mode. I was selected as a PPP partner, my lords, and I was asked to go ahead, my lords. The Sanjay Gandhi Memorial Hospital was in UP. It was chosen as the director, as the developer, and we were asked to go ahead with providing nodes. Nodes are basically, my lords, centers in all villages. It's a telemedicine comes from, it's an international standard medicine policy, my lords, which was adopted by the state of Orissa. And we have opened up nodes all across Orissa, and we would have expanded all across India also. And these nodes were open in various sectors, and suddenly, well, the government passes orders, go ahead with the policy, open the nodes. We receive accolades from various parts of the country, my lords, and then suddenly the government, for no rhyme or reason, says stop the project. Not the government. Further expansion, you just stop it. And we are stagnating from 2014. That is the sum and substance of the case, my lords.
My lord, in this case, the state government wanted to improve the scheme and wanted to review the existing that was made in 2007, my lord. That was challenged, and Honorable High Court passed a staying making further scheme as against which you moved the apex court, and the apex court disposed of the application, setting aside the High Court direction and making some guidelines. It is said that those who are operating now, petitioner, they will operate pending the formation of the scheme. Government will proceed with the formation of the scheme. And the existing operator, those who are there, they will continue till then. That was the policy that the government had taken.
I will place my lords, I gave your lordships the short dispute involved.
No, the thing is that you were already operating.
My lords, I am operating. I have.
To operate.
They are not allowing me to operate, my lords. I am just. I'll take your lordships through all the documents. Your lordships may take the documents chronologically in the list of dates and events, my lords. We have given a copy. Lordship sees the arbitrary manner in which the state government is functioning. In 2007, if your Lordship comes to page 54, 55, I'm sorry, my lords. 55. My lords, I'm giving a short note. Your lordships can refer, then I will take your lordships to the documents involved in the note.
Now, there was an observation by the Supreme Court that not put any butter into you in reviewing the policy.
Yes.
So what you are doing here, and this was done long back. It was in 2019, sir. Now we are in 2026. Reviewing of the policy still under the.
Police was stayed and all that. After Supreme Court cleared the matter in 19, my lord government.
19 it was lifted. Then 2019 to 2026, what you are doing?
Now, what is the development thereafter? No instruction has come to us, my lord.
That means
latest, your lordship by last order directed state government to file an affidavit, which we have filed on 17/5/24, my lord. After 17/5/24, what is the development as on today? On that, I have to take instruction, my lord.
This is going
Because the 23 and 26 is been listed. So I want to take instruction this matter, my lord.
This was listed to be taken up at 2 p.m. I believe, monthly in presence of the government advocate. Yes, you.
Today, yes, my lord. Today I have
Last
talked.
time
Today I have talked to the department, my lord.
When the direction was passed.
Order number 22, your lordships may see.
25 I am looking at. So Mr.
This is a single bench matter.
Was there, where he has gone?
This was a single bench matter, my lords, but
In his presence, the matter was listed today. They gave you nearly 1 month time to come ready. And you are saying that it is listed today.
Let it come next week, my lord. But the affidavit, their operational status, all that, where lordship wanted to file an affidavit, we have filed an affidavit intimating the entire fact, my lord. So far the policy is concerned, how far it has progressed, today I talked to, and
This is the 1 month time which was given to you, what to have taken. You know the Supreme Court judgment, which was delivered on 15 July 2019. And the Supreme Court has said that the process of reviewing the policy which has been undertaken by the state was certified by the interim order of the High Court. Now, we find the merit summons advanced by the such and such, the High Court cannot transgress an area of the policy. Since the writ petition is pending, no observation at the same time, is the view that no valid justification to restrain has come. The matter is purely an executive domain, and then it says that you can continue with the policy.
Every
Say that
day,
we leave it open to the state to conduct an appropriate exercise that is fit for formulating and implementing the appropriate policy.
yes, ma'am.
So what are you doing from July 2019? Now we are in the month of April 2026.
About the new policy, I have to take instruction, my lord.
I think that there is no.
But they have been operating. They have been operating.
The members of the panel of the learned advocate representing the state. This is not expected. When we fix the matter 1 month before we directed, then you should ensure that everything will be over.
Let it come next week, man.
This is all merely that you wanted a time, so the time is to be.
But they have been operating, my lord, under direction of Supreme Court.
Understand that, but you will not divulge the court that whether you have reviewed the policy or you have not reviewed the policy.
Review the policy that I
If
said we will
there is
Supreme
the
Court.
appropriate policy, then on the basis of the Supreme Court judgment, we dispose of. Show us what is the reviewed policy.
Reviewed policy, they have not, no instruction has come, my lord.
That is what is the irony.
Let it come tomorrow, day after tomorrow, I will.
You are continuing with that.
No, my lords.
Why not? The court has said that you should continue. He said
They're not allowing us to continue. That's a wrong statement, my lords. Certainly, you will not make a it's wrong statement on instructions, my lords. He's making a statement, but I am sure the instructions which have been given to him are wrong. He will never make a wrong statement, my lords. The instructions are wrong. We are not being allowed to continue. It's in direct
Last
violation of the
affidavit,
court's
you
orders.
lordship, wanted to file with Korean. to file an affidavit for your query, whether they are operating or not, or that was we have filed an affidavit.
They are operating, so where is the difficulty in operating?
My lords, there
That's an affidavit that is.
we had in fact filed an application earlier as they were not allowing us to continue. And this honorable court, order number 22 dated 23/3/23, your lordships may kindly see. 22/3/23, that is paragraph 4, you may kindly see. Internal page 7 of the order. Paragraph 4. In view of the above orders, the state government is expected to permit the trust as well as the entrepreneurs to operate the nodes which are presently in operation, and in addition thereto, 27 nodes pending further orders before the court. It is obvious that the above directions have to be implemented forthwith by the state government, since they were issued by the Supreme Court of India in the appeals filed by the state itself. They are not doing it, man. My lords, and in the affidavit, this is an affidavit dated 17/5/24. They say our services are no longer necessary. Paragraph 7. How can he take a contract?
How many writ petitions are there? Because I find two writ petitions.
Two writ petitions.
They are tagged now.
Yes, sir. There were two matters.
The other matters.
Two.
62. What is this? What is close of cases?
May I suggest one thing, my lord? Your lordship passed an interim order stating that those who are operating, they will be allowed to operate. Pending that will stipulate time, government will find.
The difficulty is that you have stopped them from operating. So if we say that those who are operating will continue to operate, then it's a farcical order because they are not operating as per their own version. You have stopped them to operate.
Whether we have stopped
that event, what is
because there is a direction to Supreme Court to operate, we do need to have stopped it. But whether we have stopped or not, on that I want to take stand. You know, we cannot stop it with the direction of the apex court. I cannot
They
disorder it.
themselves are saying so. My lords, affidavit dated 17/5. Your lordships may kindly see parasol. They say we are no longer needed. This is the affidavit filed by them after the orders of this honorable court. On order number 22.
V. After the. Where is the V? V is not there. W.
691. Yes, sir. Yes, ma'am. This one. Yes, ma'am. Got it.
Yes. Which paragraph? 7.
Paragraph 7 is referring.
Therefore, in light of the above developments, the assistance of telemedicine nodes opened by OTT-ET and the couriers selected by OTT-ET are no longer needed. And themselves say that they are no longer needed. The operations involve payments being made by the patients and or reimbursements by the state government, and therefore restricting their expansion more so in light of the aforesaid development is an immense public policy. Therefore, the writ petitions are liable to be dismissed. They are violating the orders of the apex court, fellows.
On para 7, I am making an affidavit, my lord, whether actually we have refused them or not.
It says that is not required.
It is not, expansion is not required, my lord.
The expansion comes.
But so far the operation as the direction Supreme Court order is concerned, we are bound to.
That is the subject matter of challenge in the main writ application.
Highlighting is on the basis of his instructions from his client. So do you mean to say that he is lying?
That I am not saying he is wrong. So on his submission, let me take the instruction, my lord. Actually, they have denied operation or not.
Lordships,
Let me file an affidavit to that effect.
My lords, if we were operating, I would have said that before your lordships. Your lordships will record my statement and let him take instruction.
Because they are appeal before.
I've invested more than 30 crores.
We could not have stopped them, my lord. But let me take instruction that actually they have stopped operating on. Let it come next week, my lord. I will file an affidavit of secretary.
My lords, there is a fee structure fix which is to be paid by the government. Let them show a single document to show that such fees have been released to us.
Yes, rupees 40 for each patient.
Yes, my lords. Let them show, my lords. They are saying we are allowing them to run. My learned senior is appearing on behalf of those notes.
Condition.
They are demanding from me.
ECG test. That is your affidavit. Paragraph 4.
Yes, ma'am.
Rural Health Mission. National Health Mission.
Then it most probably it's DSJ. Most probably DSJ will represent.
National Health Mission.
Rural health to the state government. National rural. I think the DSJ will.
Imbue.
I think Vibhu.
Now,
Now he's senior.
But in some NRHM cases, he also appeared.
He usually appears. That's why I'm.
Mr. Das, on the last occasion you appeared in the matter.
My name has been incorrectly. My learned friend was there, and I cannot also appear in this case because for petitioner I was appearing in this very particular case. I was for the petitioner.
We'll correct the record. Then why you did not inform that this matter is coming at 2 p.m.?
I informed parents, I sent a letter, I also contacted them over call. I was
Whom have you contacted?
the department manager, concerned
Director.
department.
Director.
As far as the mode of
You-
channel which we usually we had sent a letter addressed to all the concerned authorities.
You have to place him in the stage of consideration of this person from Honorable
Yes,
Supreme
ma'am.
Court.
With regards to that, I had sought for instruction, but secondly, this is an 10 years old man.
From operator.
Now, some also claim that area dues, what they've done, they are not in credit.
I am for the entrepreneurs who were operating the node pursuant to the direction of the Honorable Supreme Court, wherein on the Honorable Supreme Court they had filed an affidavit that total 396 entrepreneurs were selected in 2 phases. Loan was sanctioned for 127 and loan was disbursed in favor of 27 entrepreneurs. And 35 are in operation. That was the affidavit filed by them before the Honorable Supreme Court. But since they did not allow me to operate, the order number 22, I had filed writ application. Though the assignment was of the Honorable Single Judge, but since these matters, the Honorable Supreme Court had requested the Honorable Chief Justice to hear the matter. So these matters were tagged, and the then Honorable Chief Justice had passed the order to that the court expects. Yes, Your Lordship. Since that was not filed an writ application for disbursement of the fees. That was also the Honorable Chief Justice are directed to tag the matter along with this matter, Your Lordship. Till date, they are not allowing us to operate nor disbursing the fees, Your Lordship. This is the writ application. We are within the 35 as specified in the affidavit before the Honorable Supreme Court, and they have stated 30 are in operational.
35 plus 27.
Yes.
You would say 35 plus 27.
Interestingly find the state government's decision. In the impugned decision, they have passed an order not to expand it. Your Lordship must have seen it here, that is annexed clear, page 96.
That's 180.
They are taking time.
They're taking time for it.
I have no other alternative by an intervention.
Your Honor, one point, that Honorable Supreme Court has stated review of this policy. Review of the policy was undergoing at that time.
PPP modes, there are no policy.
Yes.
No.
This is not Honorable Supreme Court had to say that you are free to make the review of the policy.
In fact, and reduction permitting,
They are arguing that yes, state at one point of time, state government decided to review the policy. That is what we understood from it. That is also reflected from the Supreme Court judgment in 2019. The Supreme Court says that you can't put any restraint order which would create a fetter on them from reviewing the policy or revisiting the policy. So this is what the Supreme Court says. Set aside the order and say that now you are free to take a order.
where is permitted to?
Our first question was that it is the order of 2019 July.
Yes, sir.
What is the status, whether you have reviewed the policy or you have not reviewed the policy?
Right.
Answer is not coming. So answer is we don't know. Any instructions are not.
Correct. Sir, the rightly put that question. Sir, as far as I know, sir, this matter was argued time and again. They say, so far the Supreme Court is concerned, they also rightly said, Supreme Court said that the state government is always at liberty to change their policy. There is no bar for that. We asked that question in a coordinate bench presided by the Honorable Chief Justice, that whether you have taken any decision, policy decision, the answer is no. No. Answer is no till date. No policy decision has been taken till date. Rather, they have restrained this particular petitioner and the entrepreneurs. You will also see that both of the entrepreneurs, you made the advertisement, pursuant to the advertisement, they are selected in a particular process and they are allowed to operate and they have borrowed loan and all the accounts have been NPA now. All these entrepreneurs.
And PPP modes, they are continuing, my lord.
Yes, sir.
That even in the change in policy has to be done in accordance with law. They can't do it at their own whim and fancy.
Sir, this was a policy.
That will be tested by your lordship.
Yes, sir. The PPP policy, the PPP vote, that was the policy of the government. They don't say that the PPP policy has been violated. No. What was the improved order? Improved order in 2014 was that orders not to expand, not to further expand.
Yes,
that was the discussion.
And that was not by the government, but some officers. Not by the government. Government has not done it.
Can you also look to the Supreme Court order that has been also reflected?
Yes, sir.
Yes, sir. Yes. At page 2, you also look. Because of this, of course, the Honorable Supreme Court disposed of the matter at the stage of admission without hearing the whatever has been said, we rely upon that judgment also, order also. You also kindly look to page 52.
Page 2.
The order of the Supreme Court, the page 2. You also just one paragraph I show that. Thereafter, further directions were issued by the High Court on 13 July 2016. The High Court, in the course of direction, called upon the state to file an affidavit setting out the activities which have been undertaken by the entrepreneurs who have been selected. An affidavit was filed on behalf of the state government by the Additional Secretary of the Health and Family Welfare Department. The state explained that 396 entrepreneurs were selected in 2 phases. Loans were sanctioned to 127 entrepreneurs, but disbursement has been taken place by the bank concerned to 27 entrepreneurs. It is stated that actual disbursement to the rest was paid pursuant to letter of the MSME department under the auspices of the Chief Secretary on 7th April 2015. According to the state, 35 units were currently functional in 8 districts.
the state took a decision that unless it revisited the policy with a holistic perspective, no further expansion will be permitted. Yes, we accept that, sir. Then sir, kindly come to the bottom, that second paragraph bottom. However, just a thick line from that paragraph, from bottom. However, in the meantime, it has been submitted that the petitioner would be allowed to operate the nodes which are with the additional 27 nodes until an evaluation is made by a third party. The state government, however, submitted that it must be allowed to proceed with the selection process in a transparent manner after a request for proposal is made through the process of tendering. Let them produce the records to show that any policy decision they have changed or they have altered. Nothing like that. In course of hearing, they themselves have admitted. Of course, because the government advocate must not have, can take the instruction from his mind. Yes, sir. Let them produce the records. Nothing like. And because of that, did not take any action in terms of the order of the Honorable Apex Court, your worship, order number 22. Order number 22 was
I was just to see page 4, Roman 3, whether the state government has complied with the Honorable Supreme Court decision. Kindly see page 1 second. Page 4, Roman 3, kindly see here. In so far as the first respondent and the original petitioner before the High Court is concerned, we record the assurance of the state which was made on affidavit before the High Court and which has been reiterated in course of submission in the present proceeding, that the states are permit during pendency of the proceedings the first respondent to operate the nodes which are presently in operation in addition to 27 nodes pending further orders before the High Court. But they have not complied with this order. They have not complied with this order. That's my specific instruction. So they have not complied with the Honorable Supreme Court's order. They have not allowed a single center to operate.
Since my not place the Supreme Court order, I shall kindly look to the order of this Honorable. Order number 20. Order number 22. Yes, sir.
I was placing that order, my lords. Paragraph.
Just because you
I have already read.
Yes.
The order of the Honorable Supreme Court.
I have also read this. They have quoted the order of.
Yes, that's correct.
We want the petitions to be tagged together and to be disposed of in a particular manner. And the affidavit was also sought for.
But on this, let them take instruction. But on this Roman 3, whether they have allowed this ongoing centers to operate.
He has said that till date we have not discontinued any.
They have.
Before you step into the courtroom.
In fact, we are
the former president of the association to corroborate.
But in fact, we authorize former president to represent us here.
He is only interested for money. He said he can money.
He has the perpetual right of representing. No, this all very big high. Yes,
Yes,
I your lordship.
There are nodes at every center.
Telemedicine is a kind of system. State government adopted the procedure through official mode. Telemedicines are the centers to be tagged with district headquarter hospitals and medical colleges throughout the state.
Different villages also.
Different remote part of the states. Those who do not get access or communication problem to come to the hospital in case of emergency or in case of any immediate medical assistance, they will have centers in those specific remote locations with system, computer, internet, everything. They will come to those centers. They will be connected to the district headquarter, main doctor there at the headquarter and seek advice from them. Advice will be given to the poor man sitting in the remote village that you do this investigation, this medicine, this is the kind of facility to be given to the public at large who are as part of the state. What object is there?
Without the clinical examination of a patient.
That has to be also advised. They will advise. That has to be done by the note. That is to be done. That has to be done by the notes. The center will do that. Every investigation.
Will be managing notes.
Those trained people, they have been trained.
Technical trained.
Those 127 technically trained people, they have been imparted training for that. The Supreme Court says the trained people. You will see. To my lord, today the central government is also going to implement this telemedicine scheme. Central government is also going to implement
this. The cost is 30 rupees only, sir. Till today also, 30 rupees.
And you are not acting on this.
And sir, after this order, reviewed order, which we are challenging before your lordship, the CM in the press note says that they have received the 8th position. While this has been taken as a role model for all-round national development and acknowledged as one of the globally accepted best practices, I wish to extend my thanks to the OTTET and government which are partners of the PPP project as under the National Resource Center under the Ministry of HNFW, GOI, SP Sanjay Gandhi, PG, IMS, Lucknow. The government acknowledges us. One secretary sitting somewhere says, no, 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 stop expansion. And that is what they are continuing with.
And stop the existing centers. Those were operating hours.
Annexure, if your lordship sees, 34th page 216. This is not given by the chief minister. National Rural Health Association.
NRHM.
NRH.
Health Rural Mission.
Every program for control of blindness and national targeted programs to make people-centric telemedicine programs sustainable as per government order 2010.
Right from 2007 till 2014, several deliberations have been made under the chairmanship of the Chief Secretary, Health Secretary.
Still on.
Still, program
Yes, sir.
They are not allowing.
Page 216.
Mr. Ramdas Acharya, I think you are for NRHM.
Yes.
That was I was searching. Mr. Acharya, yes. It is still operational.
Yes.
And what about this OTT?
Well, in 2015, the CM writes, I thank OTT for this model project, which has become a role model in India, in the world. That is exactly the wordings, my lords, given by the Honorable Chief Minister. My lords, and now, and this is after this impugned order in 2014. This is a press note dated 28/5/2015.
If I think want to say something.
This is a project law of NRHM. The state has to implement the same law because we have already state government has
Supreme Court has said not to dispense the details of this.
NRHM.
Continue. Are they continuing?
Yes, it has not taken any action against them, my lord, because it has the state.
No.
With the work.
That instruction, my lord, state has
Actual
to
work.
because NHM, my lord.
Yes, you are not terminated.
During the COVID time.
State has to take a decision in this regard, my lord.
Was
Yes, it was very
meant as inevitable.
Exactly.
That is exactly the very purpose and objective of this.
During the COVID time. It
Yes.
was very much necessary. Yes, distinct medicine facilities.
Yes, sir.
This was very much.
So nowadays, you also know that the health, though the government has made a policy that they will give the benefit of health service and some free health service, but you also know the practical disadvantages of this level rural area.
No doctor is available.
No doctor, nothing.
So even if you are there, road is not there.
This matter.
Because here is simple annexure not simple. That comes to annexure one, my lease agreement.
Issued by us being without jurisdiction.
Yes, Lordship, because
Where is the include the recommendation 57?
Lordship, can you come to check that page, Lordship?
57, where it is?
That is it, Lordship, page number. Lordship, 71, annexure 5. Asking Lordship, this.
Just 1 minute. Can I go through?
Sorry.
Sir. You are Mr.
Lordship.
This was your representative.
Lordship.
Yes, no, they cancel that there is no access to the sandwich. They cannot because the previous lessee was operating and he was transporting over the another private land under the understanding. Now he has refused you that does not allow my land to be used.
Actually, my argument is twofold. First of all, I have given them alternative land. I have given them Lordship alternative land to Lordship to make it Lordship proper SSC Lordship.
When you get it?
Lordship.
In the representation, did you say?
Yes, Lordship. Annex 6 series Lordship.
What?
Annex page 73. Page Lordship 73 Lordship.
No, that is 15/7/2023. That's the date of the order.
Because
after the
15/7 Lordship without jurisdiction Lordship, without authority. Because at the relevant time, he is not the competent authority. At the relevant time, it has been already shifted to mining department.
When this order was passed in July, at that time, the custody of the sources was with Tehsildar. It was handed over to the mining officer on 22/11/2023. So therefore, since the custody of the sources was with the Tehsildar, he recommended the cancellation of
when came into force?
December
2022.
Yes, ma'am.
So how can he retain his power? Only thing is he has to transmit those records.
Yes, ma'am.
Transmission of record does not mean dealing with the records and taking a decision.
Yes, ma'am. That's the only.
So how can he? I think in some of the judgments, some of the cases we have already held that once you are denuded of power by virtue of this, you cannot assume.
Yes,
you are
ma'am.
simply a ministerial act to transmit all the records or transfer all the records to mining office.
Yes, ma'am.
That's all. Okay.
That is the only.
We are washing on that ground and directing the mining officer to decide on the basis of this.
Yes.
And take into consideration this subsequent.
Yes.
He becomes wise after receiving the order. So actually he is not, but legally he has something.
Furthermore, is the committee which conducted the verification, there the Tehsildar was a member.
There are two things. Let me visualize. Be practical in this regard.
That
It is not that the earlier lessee was not operating through a private land.
Yes.
There was no privilege. You permitted him to cross.
Yes.
Only thing is cancellation came because there is no.
There the Tehsildar was a member.
that I will not permit you to use mine.
Yes, ma'am.
That's the only ground on which you have cancelled.
Yes.
Now he says that I am giving you alternative, somebody has permitted me to use. So same position as the ex-lessee. What is the difficulty?
Yes, ma'am. My pass accepted orders.
Give me that amendment.
Notification.
Where is the amendment?
Yes, there is judgment. I'm getting
Me. You don't have a judgment, you don't have a provision of law, then what should I do?
No, in fact, my interest has been, has come, so we will file reply, but what's that, in my case,
You are appearing in this which, when, since when?
That's Dilip Kumar Saab, that is my case.
You do not know that on the first day of hearing, many matters are disposed of.
That's true, Lordship.
So, to come, which law? Give me. Mines. Mr. Raj, which is the correct provision of law? Which rules of law?
My lord, if your lordship will look at 66 of the mining rules, OMMC rules, that is the transitory provision. And
No.
in some cases also your lordship have already passed.
I pass on that. December 2022. This is another job.
The lordship have set aside and send it to the competent authority under the rules to deal with the matter. The lordship have taken note of the amendment also.
Yes.
Notification 27 December to 22.
The order number 1.
needed orders were. What? Taking into account that Suraj Agarwal and Prashant Kumar Manvi.
Oh, this is 64.
Yes, sir.
64. It's. Ms. Das?
Yes, ma'am.
Next.
Item 21.
For the petitioner, the lordships are directed to add the private respondent, which is matter, right, to serve copy upon.
Yes, sir. Who is your president? Where is the applicable service?
My lord, yes, sorry, sir. Right, but possibly that has not been checked. Here's the copy of the reverse options.
Item delivered. When?
But also this man tries an instruct to appear. Newly added party and the successful bidder got to this case.
He was hiding himself, says there is something.
No, it's me. But I'm ready with the all pleadings, lordship. Lordship, kindly see here. All suppression of facts, lordship. Let's see the two persons in the capacity of your organization. They have filed this writ application here with the party, auction bidder, lordship. And the same president, lordship, has filed application for NGT. And there are, this is fifth round litigation, lordship. The auction of 2020, they have never disclosed anything. Lordship, kindly record, just I'm giving the lordship the
File your affidavit, exposing those facts.
lordship.
2 weeks, 1 week, 3 weeks.
Rightful, lordship.
Item 23. 22.
Item 23, your lordships. The petitioner. I received the counter active yesterday only.
Yesterday, we are.
Please wonder why.
1 week.
1 week?
1 week.
1 week. They submitted accordingly that the counter affidavit is received yesterday. Therefore, therefore the police have been permitted to file the request. When the requender will.
May please on it. You're challenging annexure 13 at page 163. Lordship, may kindly have a look at that.
What?
Annexure 13, demand notice. Page 163.
24.
Page 163, annexure 13.
Yes.
Now, there are this details of excess mining of stone inside lease area in respect of Kastiya stone 22 under Baba.
How much is there?
2 crores. 2 crores 59 lakhs.
Deposit.
No, the show cause of having Lakshmi can't come to. I have not mined 2023 to.
There should be a question of fact.
No. Yes.
The refund is there. You make a.
Madam, I'm at least entitled to show cause. Your Lordship may kindly see. Your Lordship may kindly see my governments have directly stated
With reference to,
in paragraph 27.
with reference to show cause matters on so issued.
Show cause was never received by me. I'm not
talking about.
On 26, 25 by letter.
Yes.
Letter number.
This show cause was never served on me. This show cause was never served on me. One.
What are you saying? This can be served on you and that will not be served on you.
But this has not been served.
Demand has been served on you.
Demand has been served.
So, and then it's the same address. The is not served on you.
That is specifically what I'm trying to say.
Yes, who is appearing?
I'm appearing.
Only very, very small questions. Do you have the instruction or a document showing that the show cause notice was sent to him by post at the same address?
May I have received the instruction also keep it too. Just now he has given me the instruction. Just now.
Come to the next week. Page 15 of my fund.
Item 25. 25.
Yeah, further simple amendment. And your lordship by order dated 24/26 that only to file objection if any interpret.
Such objection is because it's not changing the nature character.
You are considering.
Yes.
Application for amendment of the issue. So. But they are applicable. Let's say. Let them
Will you be permitted to file counter to the consolidated petition?
Okay. Let the.
Demand notices have been issued in contravention of 306C of Income Tax Act. The counter has been filed with lordship, admitted. Their own fault, your lordship.
Yes.
The counter's affidavit has been filed in this case, your lordship. They have admitted their fault, your lordship.
Where it is not on record.
The second and third cases, the counter affidavit has
Same counter.
demand to means I am appearing on the second and third matters for the petition.
I am in the first matter, your lordship.
Because in these cases, a demand notice has been issued by the state government for collection of arrears of tax collected at source.
And the fourth and fifth is the matter is the same, where the state government has settled the arrear collected.
So the short the demand was
For the state is a contesting party.
Yes.
Where is the state?
My request for a passport, my Saswat sir is marked as a matter. Saswat sir.
As of this 6/4/2024 notification in that REIT application, those two REIT applications. In fourth and which one? In fourth and fifth year, watching. No sub-item.
Yes, Mr. Das. You have admitted that wrongly you have charged.
Here, if I may submit.
But sir, you say Mr. Das is there.
Yes, my lords, he has.
And then you are hijacking his
No,
right
my lords,
to
no, my
make a
lords.
submission.
No, my lords, no, my lords.
Challenging the demand. So also the state has filed two writ petitions which are also tagged. Those two writ petitions, no notice has been issued. So if somebody is appearing for the central government, then we can also serve copy. If the same demand challenged by the petitioners,
it's made
those cases, then also the state has.
Solution well.
I am appearing from the Union of India. In the past writ petition 599 to a copy not served on us.
But may I offer your lordships a solution? Under the statute, under section 206C, if the lessor fails to correct arrears of TCS, then they are liable to the income tax department.
That is sub-rule C.
However,
section 6.
there is a proviso, which proviso to section 206C, which has three conditions. That I have filed my returns under, that the lessee has filed his returns under section 139, that we have taken all these incomes into account, and that my accountant shall provide a certificate to the government, and utilizing that certificate under form 27BA, government can also take an exemption from the income tax department. Well, I am ready with the rejoinder where I am submitting my 27 BA certificates. They can utilize it with the income tax department. Even the state government will be exempt. It will solve the entire issue.
Case you also. In this, is the same file your rejoinder?
Well,
Where is the rejoinder?
well, sir, may I hand over?
Yes. Give him a copy.
Yes, sir. I'll hand it.
Give him a copy.
Lordship, my predicament is, in this issue, my MDC certificate cannot be issued. You can't notice period.
Oh, he's coming to your rescue. You just go through it and I think in which matter you are
Union of India, in which matter you are not served with a copy?
5992, main item, madam. 5992 of 2026, WBC.
There you are not.
There you are not a party. You are not a party there.
The main item is there.
But I believe that if he is given a copy, that will help as well. You are representing?
Well, I am in the second matter, Ghanshyam Mishra. 16811 and 16812.
Oh, देखो.
This is the certificate, the annexure 14 months.
Mr.
In first item, we have created the IE application. The IE application is pending.
Nothing.
The IE is pending in process for the issuance of the indices certificate. We cannot mine most because of this demand.
What are you doing?
Because of the demand notice, we cannot mine also.
The demand notice can't be caused in such manner.
At least a stay of the demand notice maybe.
Deposit the entire without prejudice to your rights. We are staying the demand notice. Deposit the whole of them up. Not in this. Let them come. So I was fixing a shorter date.
On 5th of May.
5th of May. You have been waiting for such a long time. 5th May is not far off. As a to be taken up at 2 p.m. Yes.
Item 27.
And I will be permitted to make the solutions. My call is not there, we will permitted to make the solution.
You are engaged by the advocate and record? So why the power is required? Why? Why it is required? No, I just wanted to understand the law. I do not know. I may be going in a very bad atmosphere. Authority to engage any advocate to argue. So if he has engaged any advocate to argue, he is not supposed to file a wakalatnama.
No, memo.
Why memo?
Memo of appearance.
Memo of appearance.
That is under our rules. Memo of appearance. Not wakalatnama.
Memo of appearance.
He authorizes. Send.
Add on.
That is our.
What is the rule which says the memo of appearances?
This High Court rules.
Where it permits?
This High Court rules, there are not. That's a normal practice. Then what
Anyhow, what is this? Give us a shot because we
perfect for assist your lordship and date chart your lordship. As it runs through the date chart so that will be your lordship sees the mining was not
76 executed.
Yes, 76 executed.
Yes.
Thereafter 12-1 amendment was carried out to the 57 Act.
Correct. That's the auction regime that came. Yes. Then
18/2/2019, petitioner referred to the so-and-so regarding extending the validity period in terms of 8A. Your lordship know the 8A says.
I know.
Yes. I'm just running through that. 1/7/2019, these validity extended by way of a supplementary agreement. Till 24/10/2000, this is wrongly stated because it should be 26, 50 years from 76. 2/5/2000. Order of the Honorable Supreme Court in IAS so allowing petition.
That's a common cause.
Yes.
Then
28, representation for regular desk plan production in terms of the High Court, all statutory clearances are given. 1/10/2024, again representation for resumption of mining operation. There are two more interim applications of file. Your lordship come to point number 10.
No, I was just thinking that you are after the auction regime or before the auction regime. You are a lessee.
Yes.
Before the auction regime.
Yes.
Then after the auction regime, what happened? Because all the leases they come to
an. The supplementary agreement was executed in terms of 8A. 8A says 50 years from the date. 8A.
Again.
No, not from the date of registration, it becomes 50 years.
Sure.
As per
No, I understood. Mr. Sanjit Mahanti was taking, I think, am I correct? He was taking shelter under that. Anyhow, we are in active consideration.
What number?
You're senior.
He was.
Let's point number 2025. Government of Orissa Department of System allows the commencement of the mine operation. 27/2025, resumption letter by the Director of Mines. 22/10, the petitioner submitted report to the authorities, department so-and-so, requesting to consider the lease period for date of duly registered deed and the additional add-on period of 14 months in lieu of the inaction of the state government in authorities from 20 so-and-so, so-and-so. My submission before your lordship in two parts. With regard to error of date, they have committed an error for which they are liable to automatically, since 8A2 kicks in, the 50-year period automatically impliedly means that my date goes to 26. But they have done that error. Now, second part of my submission is
with regard to, in view of the overriding effect, the expiry of the lease is deemed to have construed this effect from 23/5/2026. That start takes effect from 1976. And I have a legitimate expectation to that effect. And if they are not doing so, it is an administrative action which contradicts the provisions of 8A, and therefore it's otherwise of the Act. And since I have invested so much amount, which I have given at page 5, the Lordship has looked at page 5, starting from registration and stamp duty on the supplementary agreement, a vested right in favor. By virtue of 8A2, my lords. Since the state government has entered into its statutory agreement pursuant to 8A2, my right automatically follows from that provision, my lord. And the delay in allowing me to resume, despite the director's order to resume, OP number 3 sat over the matter, has not yet granted me that permission. Annexure 13 clearly states it should be allowed after checking all the statutory clearances which I have. The last point with regard to the delay on part is the state is liable. Non-consideration of the part of the state would amount to condoning delays which are detrimental to the efficiency of administration, which the Lordship will have a decision in that context.
Recent decision of the 2025 or 2026?
25, my lords. In fact, that judgment.
Justice Vikramnath.
Clear Patiwal and as in fact, this relates to limitation, but they have very succinctly dealt with the point with regard to delay on part of the state government. The Lordship schedule comes to a flag mark that particular page by Lordship convenience. I flagged that particular page. There's 69. Public policy at the bottom, just above 228 paragraphs. Roman, yes, my lords. Public policy vis-a-vis public interest matters of delay on part of the state or any of those instrumentalities, my lords. They are placed, my lords. Limitation laws are themselves grounded in public policy, as already discussed in the preceding paragraphs of the government, based on maximum interest in the public share, both in happiness. It is for the general welfare that repeatedly put litigation there. The public interest is better served by timely government action than by condoning repeated lapses. The state cannot simultaneously seek to represent the interest of the public, consistently fail to protect that very interest by allowing limitation period of lapse. Public interest is best served by ensuring efficiency and diligence in government functioning rather than by condoning its lapses as a matter of course. Thus, liberal inclination towards the state or any of its instrumentalities in matters of condonation of delay cannot be adopted merely on the presumption that the delay is not condoned. Public interest runs the risk of suffering. My case is before Lordship. When the
There are two concepts, sir. These judgments are pointed to an issue so far as the condemnation of the period is concerned.
My lords.
That there cannot be any discrimination shown to the state because the state is not a privileged litigant. So in that event, it was said that they are also accountable, the public interest vis-a-vis the public authority. So there they say that your responsibility becomes more onerous and
yes, ma'am.
I would say responsible, that you have to take all the actions in the interest of the public. And they should not suffer because of that. So that is what the court has really laid down. But now question is that in the administrative side, the principles under section 5 of the Parliament is applicable only in relation to the courts. Whether it applies to administrative authorities is a bigger question.
Madam, I'm not applying per se the principles of section 5. I'm applying the principles which have been laid down with regard to state action, my lords. But I'm trying to.
The state action is immovability in the government department is not unknown.
My lords.
Everybody knows.
His lordship has also deprecated that.
It travels from one desk to another. It hardly 5 feet or a 10 feet takes near about months to travel.
Correct. And there's a direction of the director. The deputy director open up the case should not have sat over the matter. Entire period of my lease period has been wasted, my lords. Because of that,
provision, the extension would come.
My lords, the provision with regard to extension, I am relying on 8A2. And when that period is there and the inaction is not on my part, and as your lordship has laid down in that recent judgment which your lordship represented today morning,
No, that was under Rule 64, that power of state government to relax the rules. Those are there. There is no difficulty. So we are relegating the litigants to go there so that the government may take a conscious decision in this regard. But the difficulty is that computation of a period of lease, maybe it's a mining lease or statutory lease, but you cannot dispense with the provision of the Transfer of Property Act concerning the leases. Section 110, how it is to be computed. Only exception here is that for the purpose of computation, not from the date of the execution, the date of the registration, it will occur. That's the only distinguishing feature.
My submission would be to your lordship. Since I have accrued right, there's flown in my favor pursuant to 8A2. And that accrued right has now been frustrated by the inaction of the state government. A duty is cast upon the state government.
When you are entitled to compensation or the damages, you can claim.
My lords, with regard to my registration of my supplementary agreement, I have invested, stamp duty I have invested, entire funds, it comes to roundabout, my lords, I have given the calculation.
I say 28 crores you have given.
Yes, my lords.
In your chart.
Yes,
you have given.
58 crores, my lords. 58 crores. And just because of the inaction of a particular authority, the entire lease period which was given to me by virtue of the statute has now been taken away indirectly. Frustrated, that my rights have been frustrated. So duty is cast upon this honorable court, my lords. Make good that deficit which has been put into my lords.
That's what.
Let's hear few facts, my lords, are relevant for my lords adjudication. If I may hand over a fact sheet which has been given to me by the concerned officer, my lords. Here from the very starting, my lords, Annexure 1, which is the first lease deed, which starts at page number 24.
Which one?
Page number 24 of the writ petition, my lords, where it specifies that the indenture is made of October 1975, my lords. On page number 24, which is the original lease deed, my lords, specifies the date.
No. That is what I say. There is a distinction because the execution and the registration are two different concepts. Under the Registration Act, if any document is registered, it takes effect from the date of the execution. That's the normal rule. Even a lease is not really is an exception, where the lease deed may be executed, and under the Registration Act, it can be registered within 4 months or 6 months. There is a period which is provided in the Act itself. But it will relate back to the date of an execution.
Yes,
but here it is from the date of the registration. What are we talking? Justice Murlida's judgment we have accepted. There is a provision in the Act that the lease would reckon from the date of the registration.
No, Section 8, this is a major.
What is that? No, which Act?
Mineral concession rules.
Well, it's before that, my lords, if I may refer to, well, this is a major mining.
This one.
Very interesting. Then Justice Murlidhar, my brother was a part of that judgment. I think that he has to revisit on the basis of your submission.
No, Malaj, there's a judgment of this honorable court also.
Yes, I do not
Same-
know.
31-2, Mineral Concession Rules 1960.
31-2. Yes, is registered.
However, Malaj, I may read section 8A, the MMDR Act, Malaj. Malaj, 8A6, Malaj, if I may read, Malaj. Notwithstanding anything contained in subsection 2, 3, subsection 4, the period of lease granted, Malaj, before the date of commencement of the Mines and Minerals Development Act 2025, where the mineral is used for other captive purposes, shall be extended and deemed to have been extended up to a period ending on 1st March 2020, with effect from the date of expiry of the period of renewal last May or till the completion of the renewal period, if any, or a period of 50 years from the date of grant of lease. Here, Malaj, page number 30, Malaj, of the agreement, where the lease is granted on 25th October 1975, Malaj. And in the supplementary date, which was executed between both the parties, it was extended till 2025, Malaj. And Malaj, there is a judgment of this honorable court where beyond 50 years cannot be done. And there is a specific bar under 8A4 also, Malaj, where it specifies on the expiry of the lease period, the lessee shall put up for option as per the procedure. So it has to.
I know. The younger generations have a lot of repository of energies. Wait. Go slow. Don't move so fast. You are raising a very interesting question. So let us consider this particular point on that. You are correct in that sense that subsection 6 of section 8A, it really says that notwithstanding anything contained in rule 2, I say subsection 2. Subsection 2 says all mining leases shall be granted for a period of 50 years. Correct? Then subsection 3, all mining leases shall be deemed to have been granted for a period of 50 years. And 4, it says on expiry of the lease period, the lessee shall put up for auction. Lease shall be put up for auction as per this. So it is an exception to 2, 3, 4. Notwithstanding non-obstante clause. Then it says the fees. Now we are concerned with the period of lease. Granted before the date of the commencement of this Amendment Act 2015, where mineral is used for any other shall be extended or deemed to have been extended up to such and such with the deemed period, or 50 years from the date of the grant of the lease. Not the grant. How the lease appears to have been granted. I am simply asking whether a right of the lessee commences from the date when you pass an order. Yes, we hereby agree to grant you a lease, this mining purposes. Whether that will be treated as a grant, can they continue operating the mines on the basis of that order, or a lease deed is required to be executed in order to have that agreement. That is why Rule 31 comes of the mineral concession rule. It says, where on an application for grant of a mining lease, an order has been made for grant of such lease, a lease deed in Form K, or in the form as near thereto as circumstances may require, shall be executed within 6 months from the date of the order, or within such further period as the state government may allow in this behalf. So it says that the grant has to be coupled with the execution of the lease. And then Sub-Rule 2 says the date of commencement of the period for which the mining is granted is the purpose of completion. There is a distinction. right certified from a particular date. But for the purpose of computation of the period, it has to be ascertained from the date when the law recognizes would be the starting date for commencement. It says then execution is not an important factor when it is registered. So the commencement will be from the date of the registration. And for the purpose of computation, it will be registration which will be important.
The lordship see their own letter.
Calculate the 50 years. If the commencement date is of the lease is the registration date, then the 50 years have to be counted from there. And in terms of section 110 of the Transfer of Property Act, how it is to be computed?
Show 2 pages to your lordship, page 135, their own letter. Their own letter.
You have a Transfer of Property Act, TP Act, give it to her.
The supplementary lease deed itself.
Interesting.
Here also supplementary leave did also granted till October 1970, 2000.
If the statute says 50 years and the mode of calculation is also provided, can you do it in derogation or in defiance to it? Look at 110, how the computation is to be done.
Yes, Miss Line. Since their own letter, they have stated failure of the lease period will be taken into account 20.
No. It says it will commence from a date. And for the purpose of computation, one has to do it in this way. If there is no ending date or a commencement date, or commencement, there is no ending date, and then it will run from anniversary to anniversary, and just a day before the anniversary. Duration. This is the only act which requires how to compute or calculate.
What's the general anniversary?
Specifically, it is mentioned that to hold the premises hereby granted.
I am asking you, sir, if the statute says that it will commence from a particular date, I am asking you very simple question. Can you permit him to operate the mines before the lease deed is executed?
It's here.
Please very clearly. Under the law, I do not know here what is the law. Tell me whether you can operate before the execution of the lease.
The specific instructions which I have received, my lords, here they say that the lease deed was executed on 25/10/1975. Whether they have operated from 19.
When it is, now they say that, are they saying when it is registered?
They say it is registered on 24/5/1995. Yes.
Then what about the 31/2 commencement? The commencement would be reckoned not from the date of the execution, but from the date of the registration. For the purpose of 50 years computation, madam, please consider there are two different rights.
And it's here, my lords, I will want to draw a difference between the two, my lords. Here, the language which is used is that the date of commencement of the period for which the mining lease is granted shall be from the date of registration. However, section 8A specifically mentions the word granted, my lords.
That is what I'm asking you. Madam, you when the grant of what? Lease.
Yes, my lord.
What is the purpose of the lease? How the lease can be executed? I am asking you. How the leases are to be executed? The lease is not a unilateral kabuliyat like this.
No, my lords, when both the parties
Signed.
Yes,
Now, question is, a lease may be executed for the purpose of computation of the period of the lease. One has to start from a particular day. Unless you have the starting point, how can you reach to an end point? So what is the starting point?
According to me, my
starting point is under Rule 31(2) is the date when it is registered for the purpose of computation of the period of 50 years. Madam, I believe I can't invest more energy into it.
My lords, here.
I'm done. No, let us decide. You have raised a good point, but anyhow, we'll see.
If I may be here, my lord.
Let's see what is a grant of lease and how it is to be understood.
My lords, here the supplementary deed which was executed between both the parties, my lords, where both the parties have signed. There also, both the parties have agreed that it will be till 2025, and the date is valid from 25/10/1975, page 118, my lords. It starts from 25/10/1975.
Then what about 31(2)?
And it's here, both the parties have agreed to that effect in the supplementary agreement.
When statute gives a date,
and it's however
the parties agree.
But parties are governed by the terms of the contract.
Are you aware of unequal agreements concept?
Well, it's here parties.
Are you aware?
Well, it's here.
If a party, one of the party is not in a position to dominate the other party, then he has to succumb to whatever the other party has said.
But that is a conscious submission. And here, my lords, both the parties are bound by the terms of the contract.
Already pointed out on the annexure 5. You pointed out that there is an error.
I may be permitted to file a counter affidavit in this matter because this matter will have a
cannot supersede the
and
statute.
beyond here statutorily it is barred. My
We will record your submissions on this. No difficulty. It's a pure question of law. We'll record it.
And my lords, judgment of this honorable court which
Yes, you give it to us.
Yes, my lord.
And where is Justice Muralidhar's judgment for the purpose of computation? There is judgment of the division bench. I think my brother was a party to it.
Mr. Sanjit Manti was referred.
Your senior was referring that judgment. Do you know? This was a case of a clear cut for 50 years, commencing from the date of the original lease, that is 21/2. till 21/2/74 to 22/74.
Well, it's
There was no question.
here my respectful submission is that it started from 25th October 2020, 1975.
Lease deed. Who's paying what time?
And this was executed and registered on the same day.
Yes, Manoj.
From this date to this date. See, this lease deed was valid from 21/2, but registered on 1974.
At that point of time, the 8A did not come. 8A was not there. Yes.
31/2 was also not there. You see, page 10. The supplement.
And now come, we'll consider it. Don't worry. We'll consider this judgment as well. We'll do it. Which one?